Good morning. Good morning. It's Thursday, November 30th. I can't believe it either. Ugh. I can't believe it either. It has been a day. It's been a week. I'm still kind of reeling from the Alec Murdaugh of it all. Today, we are talking a lot about the TikTok psychic case. There is a new filing from the TikTok psychic who is representing themselves. So there's that. There is a new ruling from the court that we're going to touch on. There is a new reply from the university professor. We've got one quick bit for you today. And that's what we're doing. We spent like 6 hours in South Carolina on Tuesday. So we've got a bit of a quicker stream and then some stuff coming into next week that I'm excited for. Remember, I do have a little bit of traveling. So if you are not in the Lawnerd app, you're going to want to do that so that we can update you on when I am streaming and when I am not streaming. The holidays are always kind of funky. It's just a funky time of year. The courts get weird and slow unless they're in trial, and they try to avoid being in trial this time of year. Filings kind of slow down. Everything slows down a little bit this time of year, and that's okay. We've got a lot to catch up on. And I'll tell you what's on my docket for what to catch up on, and hopefully we'll have plenty of time for Q&A today. That's my goal. So with all of that today, since it's like the week of Audacity, we're just getting into it. Speaking of the Audacity, the amount of effort I went through, this is the last time. Emily, you always say that. This is the last one. The effort it took to find like the lone holdout pumpkin cream cold brew, because the pumpkin is gone, people. In my area, the pumpkin is gone. All of the Starbucks that I've asked as I was buying new cups, they're for research purposes. All of the Starbucks I asked were like, no, we're out of pumpkin. It's not being replaced. So it's gone. If your Starbucks sells out, it's out. They're like, Thanksgiving is gone. We're on to Christmas. Everything mint. And I'm like, stop it. So most of the Starbucks near me are all out of pumpkin, and it's done for the year. They're like, move over, pumpkin. It's peppermint time, bitches. And I'm like, I just want some pumpkin. I'm going to complain about this again in a few months when they roll out the Irish cream cold brew, which I also love. And the Irish cream cold brew always disappears before St. Patrick's Day in March. And every year I'm like, WTF? Can you at least leave the Irish cream cold brew through the end of March? Like, who's making this calendar? And can you consult with me? Can we talk? I know Trader Joe's is out of the pumpkin Madelines or Madelines or however you pronounce it. It's gone. So they're like, look, if you want anything, you can have like a gingerbread latte and you'll like it. Like, you get what Starbucks to me, you get what you get and you don't get upset. Me, I'm making my coffee from home for the next few months until we get the Irish cream cold brew. And that's probably right. It's the time of year where I can make coffee at home. I mean, I can always make coffee at home. I have a glorious coffee maker. I'm embarrassed to tell you the amount I spent on it. I have a glorious coffee maker. I also have pumpkin spice. I can make a pumpkin spice cappuccino at home, but I like my routine of going to Starbucks. So this is the end, but I'll be in LA shortly for a very brief stopover to go do some stuff with YouTube. I'll be in LA briefly, and I'll tell you all about that later. After I do it and stuff. But I'll be in LA briefly, and I'll be able to do some of the oleatos, or Olettos or whatever. I like those too. Those are pretty good. So yes, I'm going to be making my own. I'm just going to make coffee until they come back with things I like, because I'm tired of the caramel cold foam, and I don't really want necessarily hot coffee in the morning. It's fine. I'll appoint myself. Stephanie's like, Emily needs to be the spokesperson and agent of holiday flavors. I will sue on behalf of the pumpkin spice. The lawsuit of pumpkin spice versus peppermint. Pumpkin spice is like, look, peppermint, can you wait till December? Can you just give us October, November? And then peppermint, you can swoop on in December, January, okay? February, March, we'll go to Irish cream. There's room for everyone. And then we can move on after March. Then they just go back to the caramel and they're like, whatever. Like, from March, the year goes like blah, 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 blah. And then back to August with the pumpkin cream. So with all of it, We should get going. We should get going. I appreciate you guys. Let us roll the intro. Let us talk TikTok psychic. You know what we're gonna do next week at some point? Texting judge. Texting judge. We're gonna have to get back to texting judge. We got some court cases we need to catch up on. I've just been A, busy, B, holidays, C, murdacity. So we've got a bunch to catch up on. One of those things is going to go in our quick bits. So let's talk about that. Let's get rolling. Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it. I need a new cord for my in-ears. I tried a new connector today, and this is the old connector. The old connector is like, it wasn't me. It might be a new cord. Audio equipment. The other thing I want to remind you of, because I try to make everything ADHD friendly, is that our sale is still going on at the Law Nerd Shop. So if you have not Law Nerd shopped yourself, I want to tell you that the sale is still ongoing at thelawnerdsshop.com. And I want to show you that you can select different size mugs at the Law Nerd Shop. Emily, is your screen ready to share? No, because I was messing with my in-ears instead of sharing my screen. The way that we do. So if you go to mugs, I know you guys love the mugs. I know you love the Bring the Emily mug. I can tell how much you love the mugs. I love that you love the mugs. I love you for loving the mugs. You can, Emily, pick one that has multiple sizes. The Bring the Emily only has the embiggen size. There we go. You can pick the 15 ounce or the 20 ounce on these mugs. And then the other one is just the larger size. So I'm going to show you the difference because now I have it in hand. This is just the 15 ounce extra large mug. The other one comes in the 15 ounce and the mega mug 20 ounce. And you can pick the sizes right there. The 20 ounce mega mug, I'm going to show you the difference real quick. Are you ready? All right, let's do this. First of all, we had the glorious black handled 12 ounce mug. This mug feels particularly cute and petite. I know a lot of you do not want your coffee petite. You said, Emily, can you embiggen this mug? And I said, not until our, supplier embiggens the mug. And then they embiggened the mug. Look at that. I'm so excited. So we now have the Bring the Emily mug in the larger size. So with the black handle, this is the 20 ounce mug with the black handle. And when you get, 15 ounce mug. This is the 15 ounce mug with the black handle. And when you get the, Emily, you'd be fired from QVC. I know. And when you get the 15 ounce mug, it is a taller mug. It holds more coffee. It's got the slightly rounded bottom, still has the black with the black handle. When you get the mega mug, the 20 ounce mega mug, it is a tankard that can be used as a weapon. It is massive. It is girthier. Look, it is a girthier mug. It is more of a square shape, but it is a larger mug. These do not come with the black handle. So the 20 ounce is a jumbo mega mug. The 15 ounce is the XL mug. And we have phased out our little darlings in the black handle because honestly, y'all said what we need is a larger mug. So 15, 20, there you go. Mega mug versus XL mug. These are the XL mugs at 15. These are the mega mugs at 20. The mega mug is absolutely girthier. She big. And then the Bring the Jury mug is the 12 ounce that are being phased out. So you can find 15 ounce mugs and 20 ounce mugs on the shop. We are phasing out the 12 ounce mugs. They work good for pen holders, but so many of you got them and were like, where's the room for the rest of the coffee? I need, ma'am, my coffee does not all fit. So we have phased to the 15-ounce mug and the 20-ounce mega mug. So the XL 15-ounce, mega mug 20-ounce. You get to depend. I like them both. They are slightly different shapes in the hand. How many times am I going to get to say girthy? This one's girthier. It's going to depend on your hands. I have large hands. Look, I played water polo. I needed big hands. If you have teeny hands, this is going to feel absolutely gargantuan. Even if you do not have teeny hands, the 20-ounce will make you feel petite. And if you love not seeing the sins of coffee past in your mug, I love the black-handled mug. I love the designs of them. But we put everything in both so that if you really want the Bring the Emily and you want the mega mug, you can make it happen. All right, y'all. That's what's going on with mugs. Stuff is still on sale. Fax hat is up there. Some of the fax hat have the not fuckery on the back in black embroidering that you can barely see. Some of them don't. You get to pick what you like. All the things. So don't forget that we still have a sale going on at the Law Nerd Shop. We try to make it easy, usable, searchable, fun. We've got the new tumblers. We've got the new, very cute influencery cold coffee cups that you can make all of your deliciousness with. Water bottles, travel mugs with the lids, all the rest of it. We have everything except the boots with the fur. And you never know. Maybe in 2024. So we've got you covered over in the Law Nerd Shop. All right. Can you get the black handle in the 20-ounce? Mindy, no. That is the one thing. We can do anything, but we can't do that. Why? Because our distributor does not offer it. Are the mugs microwave safe? I would have to check all the listings on the shop. I imagine the black one is not, based on the glazing, but I would need to check the fine print on the shop because that is not information I have off the top of my head. I have not tried to microwave my mug. Hold on. Emily, go to the shop. Microwave and dishwasher safe on these. So I would have to check the black handle mugs, but you can check them in the shop. So that. Dishwasher safe. Oh, yes. Dishwasher safe. The travel mugs are lined and they are not dishwasher friendly, but these are hand wash friendly because they have the lining that will keep them warm. Here's my suggestion for the travel mugs. If you would like the travel mugs or any mug at this time of year, particularly to stay warm longer, put a little bit of hot water in them first. So heat the mug first and then put your coffee in. It will stay hot much, much, much longer. All right. Let's see. EDB, you're going to need to start selling EDB wrist braces for the mega mugs. We've got it. We need it. Emma said the black handles are micro and dishwasher safe too. Thank you. There we go. So Fran's like, can we talk about law, please? Yes, Fran, we can. I just didn't want the law nerds, especially our neurodivergent law nerds, to miss out on the sale because in 2 weeks we're going to get emails going, so you were doing a sale. And I completely forgot. We need to remind you regularly. Lily asked a quick question. Are you going to cover the Young Thug trial? I am going to hybrid cover the Young Thug trial. Here's what I'm thinking. I am going to do some roundups on the podcast, and then we will pop in and out for parts of the trial. I will see what the audience interest is. So next week, I'm going to cover the shenanigans that have gone on so far on the podcast, talk about what the prosecutor did in the opening, because what you can't do. We're going to talk a little bit about the use of song lyrics in prosecutions and things like that. I will be covering that. Will I be doing day-to-day live streaming coverage for the 3+ months of this trial? Oh, no. No, it's a very long trial. And I've got some travel coming up. And I hate trying to jump into day-to-day coverage of a trial when I have travel. It's been a very difficult balance for me. I traveled during Murdaugh, and hated traveling during Murdaugh, and I traveled a little bit during Depp Heard and hated it too. I still get emails being like, girl, where's your coverage from this day, this afternoon? I'm like, I was on a plane. So I very much try to balance what we are doing with cases, and we will see how it is going. It's a very long trial, but I will do some roundup coverage of it, and then we'll see if we jump in to certain parts of the case. But we will be putting new things on the roster as we're getting into 2024 for sure. A lot of you asked for coverage of the P. Diddy Cassie case, and it has not been watched. So I can also see what you guys are watching and try to balance what you're asking for, what you're watching, and the rest of it. So I try to keep a balance of all the things. So we are going to do some coverage, and we're going to see how it goes. That's the goal. Are you going to do the Salt Lake City Heather Monica suit? Yes, I will do some. I just don't know when. Diddy's being sued again, like a lot. I'm not surprised. That New York statute just expired. So I'm not surprised at all that there is a new suit. So we will be adding some new things to the docket now that we are shifting into the holidays, and I should not be traveling as much. Traveling and live court coverage are just not compatible for me well. It is very difficult. But we have lots to catch up on. I feel like I've been behind since September. So we're trying. What's happening with Lizzo? There's motions to dismiss going on right now. We are going to circle back. Don't worry, we're going to circle back. Toxic Gossip Train conductor, why was it allowed to expire? The law was a 1-year law. It was written as a window. And I talk about that in the P. Diddy podcast episode, not this week's episode, but last week's episode. I go into that law. So that episode talks about the New York Adult Survivors Act. I think that's the proper name for the law. It was a 1-year window. All right, y'all, we've got to do some quick bets. Are we ready? And then we're going to do all of the TikTok psychic stuff, and then we'll do Q&A, and we'll get into it. So let's do some quick bets, or a quick bit. It's a quick bit. Does that make it a quick bite? It's just the one. Quick bit. So I got a ton of this, tagged, DMs, all the things, because there haven't been many updates in the Franke case. For those of you that have not been following the Ruby Franke, Jodi Hildebrand, Kevin Franke of it all, this is regarding, today's bit is regarding Kevin Franke and Ruby Franke and the fact that Kevin is now filed for divorce. With the criminal case, Ruby Franke and Jodi Hildebrand have been charged each with 6 counts of child abuse. It became, I think, such large news because Jodi Franke had a popular and controversial YouTube channel called 8 Passengers, and then started into a coaching business with Jodi Hildebrand. And because of the way that this came to police attention, though others had tried to bring this to police attention in the past, including one of the eldest children of this family. Jodi Hildebrand and Ruby Franke were arrested after the escape of a 12-year-old who ran to neighbors for help. Neighbors called the police. Police did an investigation. The criminal case has had nothing on the docket since mid-September. What is going on with the criminal case? I could not tell you. There has not been a hearing, or at least one that's marked on the public docket. There has not been anything going on in that public-facing criminal case. Originally, Ruby Franke and Jodi Hildebrand had both asked for expedited bail hearings. They had gotten bail hearings. They had been kept in custody. They asked for a new bail hearing and then took that off calendar, said they needed more discovery, and now nothing. Absolutely nothing. The family law case had been publicly available. It is now sealed, which I don't disagree with, especially when you're dealing with young children and children who are victims. The family law case and who has custody of the children, that is ongoing. And now there is a divorce case that has also been filed and is sort of on the docket, but is filed under seal, filed privately. So we're going to go through the brief media reporting we have on this. There's not a ton to get into with this because it is going to be private. So this is going to be about all that we know on this case. Everything else is going to be speculative. Kevin Franke files for divorce, domestic relations injunction against wife Ruby. Kevin Franke and his attorney entered a courthouse in Provo, Utah on Monday, September 18th, 2023 this is the photo that's not here because I went to reader only mode. I pulled the docket on this and I do see these filings on the docket from yesterday. This is coming out of Salt Lake City from KUTV, who has done great local coverage. I personally prefer local coverage, especially with local stories when I can find them versus larger coverage that tends to just re-report what local coverage has said anyway. Kevin Franke, husband of 8 passengers, YouTube vlogger Ruby Franke is filing for divorce and a domestic relations injunction, which is not uncommon to file for the two of them together, outlining stringent measures to govern the conduct of both parties involved. I mean, she's still in custody, so that's not a shock. The petition for divorce is private, which is unusual to me, but it's not completely out of the norm. It is an option to file it privately. She's in custody. It might be filed privately just so they don't talk about custody of the children because that part of the case is sealed. So this might just be to keep the child custody portion of the divorce, which is a factor in any divorce where children are present. The child custody is going to be a factor of this. And because that's also subject to another court proceeding, it might be that filing this privately keeps that other court proceeding also private. So it might be just to keep those two cases out of the public eye. The injunction imposes several restrictions on the parties to ensure a peaceful and fair proceeding. This is not uncommon. Key provisions include prohibitions against harassment, domestic violence, and misuse of personal information. Again, Ruby Franke's in jail. So unless she is bailed out, this really won't come into play too much. But could she be bailed out at some time in the future? It is always a possibility. Do I think that's likely at this point based on everything we've seen? No. Is it a possibility? Yes, it is possible. This is a case where bail could be issued or set at an amount she may be able to pay. According to the injunction, the Frankes are barred from engaging in any actions that would disturb the peace and safety of another. This is very common in divorce proceedings. This includes bans on electronic harassment and any form of abuse. Also not uncommon. Concerning property, the injunction forbids the transfer, concealment, or disposal of any assets without mutual consent or court order. Not uncommon. This move aims to prevent the dissipation of assets before the equitable division of the assets. The equitable division of the assets before the equitable distribution in the divorce proceedings. So Ruby can't, access her bank by phone and distribute assets to, I don't know, a family member or whatever. Furthermore, the court has placed particular emphasis on the welfare of minor children involved, restricts both parties from making derogatory remarks about each other. Again, these are not unusual provisions at the beginning of a divorce. This is a very common thing. It restricts both parties from making derogatory remarks about each other in the presence of their children and from influencing the children's views regarding custody or parent time. A lot of this isn't even going to be relevant while she's in custody. And the restrictions on making derogatory remarks, let me be clear, this does not prevent Kevin Franke from potentially being called to testify. Now, could spousal privilege prevent him from being called to testify? To some things, perhaps that could perhaps be an issue down the road in the criminal case. But if Kevin Franke was aware of the things that were going on at the time of arrest, we've got other questions about why he has not been charged, even though it does seem he's been investigated. It says that the injunction remains until the divorce. Why is that hard to say? Until the divorce decree is final, not unusual, or dismissed. I'm surprised it took this long after the arrest to file for divorce. It is not uncommon to see divorces come on the heels of arrests. I am not surprised by any of this. None of this seems unusual, suspicious, out of the ordinary. All of this seems pretty standard protocol. The things that's going to be unusual in this case is proceeding in the divorce while somebody is in custody, and how the two courts will have to work together with regard to custody of the children, because there is a child welfare case ongoing, and then this divorce will be ongoing, and you will have more courts involved than in your typical divorce, where you're just having two people dissolve a marriage with minor children involved. This will be different because of that child custody case. So with all of that, we can, really move on from this case. I don't know when we're going to see anything happening in the criminal case. I don't know what's going on in the criminal case. They might just be in the realms of discovery if there's quite a lot of digital evidence. We have not seen any additional charges brought, nobody else being charged. We've heard nothing else really about this case. So what's going to happen next with the criminal case? I don't know. Why has it been silent for a couple months? I don't know. Do I think we'll hear anything before the new year? Probably not. How long will a divorce take while somebody's in custody? 6 months to a year, maybe. I don't know if Ruby Franke will contest it. I don't know if she'll be able to contest. Normally, the child custody is normally the thing that holds up divorces when there aren't substantial assets to be distributed. So could that all go much quicker because it's being handled by the other court? Maybe. So do I think this will be resolved inside of a year? The divorce, maybe. The criminal case, it would surprise me. It would absolutely surprise me. So with all of that, there's not much more to talk about with 8 passengers, is there? Not really. So hopefully that's a summary of what's going on with 8 passengers. Not really much more that we need to say. Let's get into the rest of today, shall we? All right. I saw that a number of you have questions about spousal privilege. How can spousal privilege exist? It does. It is codified by most jurisdictions. Whose privilege is it? Well, could Ruby Franke use her spousal privilege to stop her husband from testifying? To some things, yes. So Sleepy Vapor says, is spousal privilege not his to claim? It's both of theirs to claim. So you could block your spouse from testifying. So it really depends. She could assert spousal privilege to stop him from testifying down the road. That could absolutely happen. Everyone in the 8 passengers case gives me the biggest ick. Fair. So, can't use it to hide crimes. You can use it to stop testimony, though. You cannot compel a spouse to testify against another spouse, and a spouse could try to block it. Now, this is something that would have to be litigated, but it is an issue that's there. Ray says, I don't think it applies to child abuse. I would have to go through all of the sections codified in Utah to see what their exceptions were. This would all be litigated. Would she try it? Absolutely. Leslie said he filed for divorce. He did, but anything that happens before the divorce can fall under privilege. So we would have to see. But if they're divorced, can they still block each other for things that happen before the divorce? What if the spouse wants to testify? If the spouse wants to testify, the other spouse can attempt to block it in court. This would be subject to substantial litigation. So that is what it is. So we will see. But after divorce, anything that happens after, we will see. Lyndon said all privilege has an exception, some more than others. With everything in law, there are exceptions. There will be lots of motion practice. To me, spousal privilege feels like something left from when wives basically were the property of their husbands. I wouldn't be surprised. I wouldn't be surprised. So I wouldn't be surprised about that. A lot of these laws are very old and come from older things, but also part of the concept behind spousal privilege, and this didn't come up a ton in my practice at all. Part of the thought behind it is there are people you should be able to trust in when you speak openly to them. Therapists, doctors, priests, or religious leaders, spouses. This thought that there are some conversations that should not be disclosed. But of course, like anything, there are exceptions to that. And we will see. Have I gone through all of the Utah exceptions? No. Do I practice in Utah? Also, no. Does this most often come up in things like business litigation? Yes. Are there going to be more litigation over it in a criminal case? Yes. Does Kevin Franke know anything? He says he doesn't, but I covered that in another podcast about why Kevin Franke wasn't being charged. So, with all of that, we need to talk about TikTok psychics, don't we? Don't we? We have a lot to talk about with the TikTok psychic. So shall we hop on our plane and go to Idaho, from Utah to Idaho? Not very far, not a super long flight. It'll be a quick flight. Emily, are all your notes pulled up? No. Let's go to Idaho, shall we, folks? For those of you not super familiar with the TikTok defamation case and the TikTok psychic, I'm going to do my best to give you a really quick summary. After 4 students from the University of Idaho were murdered, a self-purported psychic on TikTok started espousing the theory that a history professor from the University of Idaho is the one who is behind the murders, either by committing them or by hiring someone to carry them out. And that this professor had an affair with one of the victims, and that was the impetus for these murders. That TikToker is representing themselves in the federal defamation case that the University of Idaho professor brought against the TikToker. Why do I keep calling the TikToker? I do not like making people who do things that are completely unhinged infamous by saying their name over and over again. So we have gone with the professor and the TikToker so that we are not bringing more attention. Look, there are those on social media, not all, but some. Any attention is good attention. I am not trying to make anyone more infamous by any attention is good attention. This is not good attention. This is not good at all. And defamation cases are something that are fascinating to me. The judge here has been incredibly patient and measured. The judge had also said in a filing that their tolerance for flouting the essentially dignity of this case is going to be minimal. The judge is over it from the beginning. Though the TikToker did go onto their YouTube channel, I don't know if they're still on TikTok or not, and threatened to sue 2 commentators who have been covering this case, Atuzzi and Marquis. Go look at their videos covering this case if you would like more information, because they bring up the clips of the videos and stuff outside of the court documents if you want to see coverage of kind of that backstory. The TikToker also called the judge corrupt, amongst other things, which is also probably not going to go well if anyone brings it to the judge's attention. So the university professor sued the TikToker. The TikToker didn't respond. The professor, through lawyers, moved for a clerk's entry of default and a default judgment. And the court set aside the default, saying, we're going to give this pro per self-represented non-lawyer defendant an opportunity. And with that opportunity, the TikToker filed 11 counterclaims trying to sue not only the professor who sued her, but the professor's lawyers as well. So we are still dealing with litigation in the realm of the TikToker's counterclaims, all of which have been dismissed. Or get dismissed today. The pending motion that we have not finished dealing with is the motion for summary judgment that we are dealing with today. The motion for summary judgment is the university professor saying, hey, the TikToker failed to answer any of the discovery and therefore has now admitted everything. So the university professor is asking the court to determine liability and then allow trial to go forward only on the amount of damages. Wolf Kiara in the chat said, question, can calling the judge corrupt be a really bad idea? The limit does not exist on how bad of an idea that is. Pixelpia, do we need a code for the sale in the store? No, it is in a banner at the top of the shop. It is an automatic discount. If you are not seeing it when you go to checkout, please email us. But it is 10% off orders over 50, 15% off orders over 75 USD. So we have a response from the TikToker to the motion of summary judgment, a reply to that response by the university professor, and an order of the court. I think we're going to do the order of the court first, even though it's a little bit out of time, because the court's order is relating to older motions. Remember, the TikToker filed their first answer with 11 counterclaims, and the court was like, what? And the defense was like, this is procedurally improper. Then it got refiled, still with multiple counterclaims. Then there was a hearing. All of this I've covered. I don't know if we need to break the TikTok psychic lawsuit out into its own playlist at this point, but we might. So the judge has issued a new decision and order. So let me pull that up. Where it should be right here. No, where is it? Sigh. Give me 3 seconds to find why it's not in the folder where it's supposed to be. This is this should be it. Oh, because I titled it wrong. Duh. Me being me. All right, that's why I couldn't find it. Here we go. Let's start there. Let's start with the judge's memorandum decision and order regarding the defendant's motion to set aside and motion to dismiss. Let's start there. We've got a lot of motions today, so buckle up. We're not going to go through all of the law on all of these motions because some of it gets very repetitive to things we've already covered. We're going to go to mostly the reasoning. All right. Let's add this, do that. Yay. All right, y'all. Let's get ready to roll. Professor versus TikToker. Pending before the court is defendant TikToker's motion to set aside and dismiss collectively. In the interest of avoiding delay and because the court conclusively finds the decisional process would not be significantly aided by oral argument, the motion will be decided on the record and without oral argument, as discussed more fully below. The motion is denied. So the counterclaims have been dismissed, but the TikToker moved to dismiss and set aside the lawsuit. Nancy, the TikToker has threatened to sue both Marquis and Atuzzi. I have not seen any lawsuit filed, and I don't think that's ever going to happen. So there's that. Factual and procedural background. This case arises out of the tragic murder of 4 University of Idaho students in November 2022. I cannot believe it's already been a year. Plaintiff is a professor at the University of Idaho, alleges that she never met the students, was not involved with their murders in any way. Notwithstanding, plaintiff alleges that defendant posted over 100 sensational TikTok videos falsely claiming that she had an inappropriate romantic affair with one of the victims and then ordered the murder to prevent the affair from coming to light. In turn, plaintiff initiated this action on December 21st, 2022, asserting 2 defamation claims against defendant. One is premised on false statements regarding plaintiff's involvement with the murders themselves. The other is premised upon the false statements regarding plaintiff's alleged romantic relationship with one of the murdered students. So 2 counts of defamation, one regarding the murders, one regarding the affair. We went very thoroughly through that in the motions to dismiss with regard to defamation per se, reputational harm, etc. Defendant representing herself did not immediately respond to plaintiff's complaint. Emily, you should have just read the court summary instead of summarizing it yourself. Every single time. Every single time. Every single time. Every single time. Defendant representing herself did not immediately respond to plaintiff's complaint by January 17th, 2023, the deadline. As a result, pursuant to Rule 55A, plaintiff moved for an entry of default on January 19th, 2023. A clerk's entry was entered and then mailed to defendant on January 27th, 2023. On February 16th, defendant moved to set aside the entry of default. Plaintiff responded the next day, opposing the efforts to set aside the default and filing a motion for default judgment. Remember, asking for money there. On April 24th, the parties consented to the undersigned's jurisdiction. Note, consented to jurisdiction. All of you are like, isn't jurisdiction the first thing we need to decide in a lawsuit? Yes. Isn't it really important in a federal lawsuit? Yes. Doesn't this TikToker reside outside of the state of Idaho? Also, yes. Would a lawyer have advised this TikToker to fight jurisdiction in Idaho? Yes. Would that have possibly gone the way it went in the Tati Westbrook Washington state defamation suit against a YouTuber? Maybe. Trying to extend jurisdiction for things said over the internet is something that is fought over quite consistently and something that the law is not always willing to do. The law leans more towards, if you want to sue them, go to them. You can't bring them to you. You go to them. Go sue in the home jurisdiction of this plaintiff, which we know to be Texas, or this defendant, which we know to be Texas, not Idaho. But there was no lawyer to advise her. And well, the TikToker kind of mentioned that maybe jurisdiction wasn't right. She also waived jurisdiction in the way she went about her proceedings. I'm not going to get into it any further because I am not giving anyone legal advice, nor do I wish to aid. Also, it is too late. But is jurisdiction the first thing that needs to be determined with an attorney? Yes. Look, oh shit, Emily, are you sidebarring about jurisdiction? Yeah, I didn't think it was going to happen, but now it is. I think the biggest win in the Johnny Depp Amber Heard case for Johnny Depp was being able to establish jurisdiction in Virginia. The Virginia laws are friendlier. The anti-SLAPP statute is a defense. It's not a preemptive matter before discovery. I think if the Johnny Depp Amber Heard defamation case had never gone to discovery, there was almost zero chance that Johnny Depp ever could have won that case. Getting jurisdiction in Virginia was the biggest win in that case because jurisdiction can be that important. Laws in the United States can vary they might seem minimal to the non-legal eye, but can vary in pretty substantial ways for particularly civil cases. So fighting over jurisdiction is often the most important part of the case. We also saw this in a case between YouTubers that I covered a few years ago because the result was funny to me. And that was Romeo Lacoste suing Keemstar in California. Keemstar, it's my understanding, lives somewhere in New York State. Could there have been a fight over jurisdiction in that case? Yes. But the lawyers said, hey, the anti-SLAPP law is really friendly to us in California. So instead of spending the money to fight this case and get it sent to New York, where the anti-SLAPP law is not as good for us, why don't we just fight on the anti-SLAPP in California? They fought on the anti-SLAPP in California. They won attorney's fees. And that's how we ended up with an exchange of a play button as part of the settlement of attorney's fees. So it's worth it for the lols to talk about that case. But jurisdiction determined the outcome of that case. Had they spent the time and money to fight jurisdiction into New York, they wouldn't have been able to use California's much more friendly anti-SLAPP provision that ultimately ended up with them getting attorney's fees. Jurisdiction is the earliest part of the case. Often when we look at cases in the initial filings, I will make a note like, oh, it's interesting. They're just like, jurisdiction is proper here, but is it though? It matters tremendously. Clever lawyers will navigate jurisdiction to the best and utmost benefit of their client. But I don't think I ever would have thought to try to move jurisdiction to Virginia in the Depp Heard case. But I am not a civil attorney doing that work day in and day out. But I don't know if every civil attorney doing that work at the top of their game would have thought of it either. It was tremendously clever. It was tremendously calculated, and it worked to a tremendous benefit to them and their client. That's what lawyers are there for. So the TikToker should have asked their lawyer about whether jurisdiction was proper in Idaho, but ask your lawyer. Ask your lawyer. So on April 23rd, the parties consented to the undersigned's jurisdiction. Thereafter, on April 26th, the court granted defendant's motion to set aside entry of default. So the court said, I will set aside the default and let you answer. On May 16th, defendant filed an answer, affirmative defenses, and counterclaims to the complaint. Within the answer and counterclaims, TikToker denied that she defamed plaintiff because the accusations made against plaintiff in the TikTok videos are, quote unquote, substantially true. The court, substantially true. Substantially true. Defendant maintained that she, quote, used her spiritual brain, these are direct quotes, used her spiritual brain, intuition, spiritual practice, and investigative skills to uncover the truth regarding the murder of 4 University of Idaho students and publish her findings on her TikTok social media platform. I will say that I think being somewhat intuitive is great. I do not think it is a way to accuse someone of murder. Defendant also affirmatively asserted 11 counterclaims against both plaintiff and her legal counsel. On June 6th, plaintiff moved to dismiss defendant's counterclaims against her. A week later, plaintiff moved to quash the summons for her counsel, arguing that their issuance was procedurally improper. Defendant opposed each of these motions. In an August 8th memo and decision covered in other content here, the court granted the plaintiff's motion to dismiss insofar as it dismissed defendant's counterclaims against plaintiff and granted plaintiff's motion to quash footnote 1 from the court. However, the court did not award attorney's fees to plaintiff. In this limited respect, plaintiff's motion to dismiss was denied. They keep asking for attorney fees. One of these days, they might get it. Now, via the pending motion, defendant requests that the August 8th memorandum decision and order be set aside. Your Honor, please reverse yourself. Please check yourself before you wreck my case. Because 1, this court does not have subject matter jurisdiction over the action. It's too late. It's too late. Go back. Go back. Go back. It's too late. You've consented to jurisdiction. That ship has sailed. The boats have been burned. Your Honor, check your ruling because you don't have jurisdiction over me. This court does not have personal jurisdiction over her, and venue is improper in Idaho, and the court lacks judicial impartiality, and the court does not have subject matter jurisdiction over the plausibility of spiritual practices. Do we remember this motion now? I don't even go here, Your Honor, and neither do you. So you can't yeet my case because I don't even have to listen to you. And you don't have jurisdiction over the plausibility of spiritual practices. Meh. According to defendant, these same reasons similarly warrant the dismissal of the plaintiff's complaint. Plaintiff opposes the motion in its entirety and requests the reimbursement of attorney's fees. Do we see the attorney's fees coming up over and over and over and over again? Emma Mack in the chat said, it's giving, you're not my mom, you can't tell me what to do. It's giving Cartman, I do what I want. I do what I want. I'm waiting for her to ask the court to get her a pot pie. Wolf Kiara said, is she this stubborn or is she making a mockery of the system? I would go with stubborn. World of Witty asks, wouldn't this fall under freedom of religion? World of Witty, this comes up in a lot of the defendant's motions. Freedom of religion does not entitle you to defame someone else or commit other crimes. So there were multiple motions about this. Some of the examples being given were things like, if human sacrifice is part of your religion, it still does not excuse you for, murder. So there are things you can't do, even if they are part of your religion. Freedom of religion allows you to not be discriminated against if you need to leave work so you can observe the Sabbath and get home in time before the sun goes down. These types of things with freedom of religion. The state cannot limit your ability to practice your religion, but that doesn't mean you can use any religious practice to defame someone else. Hopefully that helps. So yes, she can practice whatever practice she would like, but you can't go on the internet and accuse somebody of murder. You cannot do. You cannot do. What's wild to me? Damn it, Emily. That was the best sidebar noise ever. What really gets me, and this, I think Marquis and Atuzi both covered this, is this TikToker went on to a video on YouTube and said that they intended to sue those two commentators for covering this case, quote, because you can't just go on the internet and say whatever you want. So, stubbornness, lack of self-awareness, I don't know. You let me know. But wants to sue them because you can't just go on the internet and say whatever you want. So we're somewhere on the linear graph of fuck around and find out. We're getting closer to the find out end. Legal standards. And the court goes through each legal standard in a more thorough way than I have seen most courts do. Rule 60B, Rule 60B4, Rule 60B6, Rule 12, Rule 12B1, Rule 12B2, Rule 12B, come on, 12B6. It's like a bingo game. Rule 12B6. The court is going through all of the standards. We're going directly to the discussion, because I want to hear what the court has to say. The court has subject matter jurisdiction. Tell me more. Federal courts have original jurisdiction over cases where complete diversity exists between the parties and the amount in controversy exceeds $75,000. SMJ. If you ever wanted to know about subject matter jurisdiction, there's what you need to put at the top of your notes in the first week of law school. Complete diversity, amount exceeds $75,000. That is all. Complete diversity of parties means they're in different spaces. The professor is in Idaho. The TikToker is in Texas. So did subject matter jurisdiction exist in this case? Yes. Subject matter jurisdiction did exist in this case because diversity jurisdiction existed in this case. Here, plaintiff alleges the jurisdiction is improper under 28 U.S.C. 1332 because there is a diversity of citizenship and the amount exceeds $75,000. Defendant disagrees. Tell me more about that. She argues that while the parties may be citizens of different states, her TikTok videos claiming that plaintiff had an affair with a student and ordered the murder of 4 students to cover up the affair did not actually cause plaintiff to suffer any damages. Your Honor, I can't do my assignment if she didn't do hers. We're talking about Haiti, and she's talking about some garden party. Your Honor, what I say on TikTok didn't create any damage. So there can't be any damage over $75,000 because there's no damage at all. Katrina, are you fucking kidding me? Am I being punked? No, that's what she said. No, that's what she said. This is the court reiterating what the defendant said. This does not mean meme. This is the memo, and this is the cite. Docket number 50-1. According to defendant, the court, shady. The court, according to defendant, in defendant's world, according to defendant without damages, there is no legitimate amount in controversy and thus no diversity jurisdiction, which renders the court's August 8th, 2023 memorandum decision order void under Rule 60b-4 and warrants the dismissal. Here's the thing. I can see how, when you don't understand the law, that you might get there logically to make that argument. This is not an illogical argument. It is not a correct argument, but it is not an illogical argument. You are dealing with very linear thought in this process. This is a very linear argument. But Your Honor, I don't believe she's damaged. And if she's not damaged, there can't be an amount in controversy. And if there's not an amount in controversy, there can't be subject matter jurisdiction. It is a linear argument. It is a wrong argument, but it is a linear argument. It's like sometimes trying to argue logic with, a teen that doesn't quite have all the facts in hand. So it is a misinterpretation of the law, but their lawyer could have pointed that out to them. Here, defendant essentially brings a facial challenge to plaintiff's complaint that plaintiff's allegations, even when taken as true, fail to show an amount in controversy exceeds $75,000. Defendant points to the fact that plaintiff neither lost her job nor was prevented from advancing in her field. Look, Your Honor, show me where she's damaged. She didn't get fired. She didn't lose her job. What's the harm? What's the harm is the argument here. Defendant did not harm plaintiff's reputation. This is a direct quote. The court is directly quoting the defense motion. Defendant did not harm plaintiff's reputation. In fact, plaintiff's reputation increased positively as proven by news media, social media, and her GoFundMe. Defendant also questions the extent of plaintiff's alleged severe mental distress and, relatedly, how defendant could have caused such injuries when it was plaintiff who killed the 4 University of Idaho students. Your Honor, she's distressed because she's a murderer, not because I said that she's a murderer. That's the argument. So defendant questioned how defendant could have even caused severe mental injury or severe mental distress when it was plaintiff who killed the 4 University of Idaho students in the first instance, and nobody believed in the power of the tarot and defendant's psychic abilities anyway. Your Honor, no one even believes what I'm saying. She also argues it's true. She argues no one believes her, but also it's true. Your Honor, no one believes in my psychic abilities. But this same defendant also argued elsewhere in motions that her reputation was damaged when she tried to bring counterclaims against the lawyer for going to the media, that her business suffered, that her social media business suffered. The court is now quoting, case law. In a diversity case originally filed in federal court, the sum claimed in the complaint controls if the claim is apparently made in good faith. It must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. If you're the jury, we're going to do a poll. Hopefully it works. If it doesn't, screenshot me and let me know. We've let the powers that be know that the polls weren't working. If you are the jury, assuming, this poll is assuming that liability is proven in this case. It has not been proven yet. So I'm going to do a poll. Over 75,000. Over. You guys have heard this case. If you're new to this case, you can let me know in the chat. Me, am I bad at typing polls while I'm thinking and talking? Yes. But hopefully you'll be able to see it. Here's the question I'm asking. You are the jury. How much are the damages? Assuming liability is proven for defamation here, arguendo, and you're on the jury and you're told this TikToker made over 100 TikToks that got covered in international media accusing this professor of murder, and you get to give compensatory damages, which of course we don't have argument on how much she spent on therapy, how much she spent trying to deal with the media, how much she spent on lawyers, how much she actually spent, plus potentially punitive damages. How much are you awarding if you get to just give money? So the options are over 75,000, over 500,000, over $1 million, or the limit does not exist. There you go. So assuming that the TikToker is proved to defame the professor, how much would you grant in damages? How much is it worth having your name constantly linked to being accused of murder in the media, to your future advancement, to the harassment that you suffered, all of it? For those of you saying the poll is blank, try to refresh. I think this is a known issue. Some of you can't see it. Some of you can. Some of you are saying no poll in blank mode. So, all right, y'all. For those of you that can't see it, I apologize. Just put your answer in the chat. Some of you can see it. Some of you cannot. We're working on a glitch on YouTube. I can see the poll in dark mode. So I'm sorry that you guys can't. Let us continue. Let's see. There must be a legal certainty that the damages are wrong. And then the court spells it out. The legal certainty test permits a district court to dismiss the case for lack of jurisdiction only if it is obvious on the face of the complaint that the suit cannot involve the necessary amount. This standard, quote, makes it very difficult to secure a dismissal of a case on the ground that it does not appear to satisfy the jurisdictional amount required. Oh, Sean said, Emily, you did not give an option for under 75K. You're right, I didn't. That's terrible of me. Let's do a new poll. That is a biased poll. That is not written well. All right, let's do that. I'm going to end this poll and try a new one. Miguelina, if you see the issue with the poll, will you screenshot it for me? Let's start a poll. You are the jury. It was a flawed poll. Let's see. Under 75K. Over 75K. We'll just do over $1 million. Over. Knowing that that'll never be collected. And then the limit does not exist. That just shows that you're mad about this case. All right, trying again. Let's see. I'm on dark mode and on the phone and could see it fine. Some people can, some people can't. How much did the TikToker make from the videos? We have no idea. They're still in discovery. So, can you read the options in order? Yes, I can. For the poll, you're the jury. How much are you awarding? First answer, under 75K. Second, over 75K. Third, over $1 million. Fourth, the limit does not exist. So the new poll is now up. And here, you guys give me 1 second. Let me make a note real quick. We're gonna take a brief pause. The music bed is how fast I'm going to go. I'm just going to make a note. I'm letting people know I'm live now. Lots of poll issues. All right. I was letting the people know that the polls are not consistently working on the live stream. Let me send them a link to the live. I'll leave this poll up for a while. And then if anybody sees an issue with it and screenshots it, let me know. So the blank poll is happening on phone. Thank you, Miguelina. And if you'll send one to me as well, then I can send it along too. All right, y'all. Thank you for the pause. It might be a mobile issue. Let me see if I can do it on mobile. Now I'm just trying to recreate the issue. Why am I trying to fix this? This is not a me problem. Well, it's a frustration. It's a me frustration. Are you now fixated on the poll? Maybe. Maybe. Let me see if I can see it. I can see the poll. I don't have a poll at all on my mobile. That's interesting. All right. For all of you that were like ADHD, yes. Yes. Okay, we've got all the screenshots. Thanks all. All right, let's continue on with this. Let's see. To be sure, just 3 situations meet the legal certainty standard. 1, when the terms of a contract limit the plaintiff's possible recovery. You will see this, a lot of you will see this in contracts for services. Tickets for Ticketmaster, things like that. You will see this limitation in those contracts where the amount of recovery is limited to the amount spent. So if you spend $10,000 on a service and you sue, it might limit the recovery to the $10,000 amount of the service. Therefore, you can't bring it in federal court because it's under that $75,000 range. It is limited to the amount of the service or whatever. 2, when a specific rule of law or measure of damages limits the amount of damages recoverable, that would be by statute, when independent facts show the amount of damages was claimed merely to obtain federal jurisdiction. Defendant's argument most clearly aligns with the 3rd scenario. Importantly, however, these arguments only represent challenges to what plaintiffs may ultimately recover. They do not involve any, oh dear.
The judge sass. The judge sass.
Importantly, however, those arguments, defendant's arguments, only represent challenges to what plaintiff may ultimately recover. The defendant's arguments do not involve any objective, upfront criticism of plaintiff's claim to damages, or for that matter, the amount of those damages. The court said, As a result, defendant's arguments represent an attempt to do what the Ninth Circuit has prohibited. The Ninth Circuit governs over this area. Smuggle in merits-based arguments into the jurisdictional inquiry. The court's not going to let you smuggle in arguments. Nope. The Ninth Circuit has cautioned. This is Judge Sass for your lawyer would have known this. As the Ninth Circuit has cautioned, if a district court had to evaluate every possible defense that could reduce recovery below the jurisdictional amount, the district court would essentially have to decide the merits of the case before it could determine if it had jurisdiction, which is not, it's the ass backward way round. You can't do it that way. Brandy said, oh, the judge is giving the business. The judge is very clearly giving the, no, the law specifically prohibits this. Here, Defendant's TikTok videos accuse plaintiff not only of having an improper relationship with a student, but then masterminding the murder of 4 students to keep that relationship a secret. Plaintiff alleges that these videos are defamatory and that she suffered actual injuries in her life, career, and mental health as a result. Without weighing in on the merits of these claims, without saying whether or not she is liable for these things, the court is saying, could the damages exceed $75,000? Yes. Without weighing in on the merits of these claims, it is not unreasonable for a plaintiff to seek damages that compensate her for those alleged injuries, nor is it inconceivable that such damage exceed $75,000 depending on the nature and extent of those injuries. That the parties dispute the facts informing these aspects of plaintiff's case are not resolved here, but instead must be determined by the trier of fact based upon the evidence. As such, the court cannot find a legal certainty that plaintiff's claim for damages are really less than $75,000 and simply a procedural maneuver to falsely obtain federal jurisdiction. Defendant's motion is denied in this respect. The court is very patiently laying out the law and saying, this is very obviously a problem. This is very obviously not the law. And this is the district court level jurisdiction. This is what the Ninth Circuit has said about it. And here is very clear case law saying, fuck off. That's not what the court is saying. The court is saying this is very clear case law saying that I am declined to acquiesce to your request. The court has personal jurisdiction over defendant. Oh, yes, let's get into how the defendant themselves acceded to jurisdiction. Yes. Amanda said in the chat, isn't Ashley representing herself? Yes, TikToker is self-represented. But like with Darrell Brooks, when I said you should ask your lawyer, I will continue to say you should ask your lawyer. Your lawyer would have known this. In this case, the defendant has chosen to be their own lawyer. I think that is an error. But I will continue to say your lawyer would have known this. You should have asked your lawyer about this, just like I did to Darrell Brooks the entire time he represented himself. We're going to keep same. If you represent yourself, even if you're a lawyer, I would say your lawyer should have known this because lawyers can be tremendously short-sighted when they are the ones involved in the litigation. There is a very, very, very common saying, and I don't know whose saying it is, but the lawyer who represents themselves has a fool for a client. I think you can extend that to yes, to what Mama Bear in the chat said. A pro se lawyer has a fool for a client. The thing with civil litigation, and this is something worthy of conversation, it's just not going to be a conversation today. But this is something worthy of conversation. Is the US legal system gotten so expensive that lawyers are inaccessible in this type of civil litigation? Is it worthy of conversation that protecting your rights has become, he who has the most money has the most rights? And that is a conversation absolutely worthy of discussion, because legal representation is tremendously expensive and it can be a problem. The reason I have a bit less empathy in this circumstance is because multiple cease and desists were sent. Could this YouTuber have taken down the videos and chose to ceaseth and desisteth? Yes. But without seeming to have any factual, objective evidence in this case, they chose to persist. And they put the plaintiff in this case, in my opinion, in a position where the plaintiff had no other option but to sue to make it stop. This is not someone who I feel is being harassed by a lawsuit, the defendant, who is at no option but to be hammered by a lawsuit wrongly. They could have stopped this and chose not to. I don't see this as abusive litigation. I see this as a consequence to an action. So I have less empathy for the fact that attorneys are expensive when you chose to fuck around and find out. The professor had no other choice, it seems, than to pursue expensive litigation to clear her name because the TikToker wasn't going to stop. And at the end of the day, the TikToker is not going to have a lot of money to pay back this judgment. So vindicating yourself in the civil system can be tremendously expensive. And that is something that is worth discussing. I hate it when people pursue abusive litigation just because they have more money. Does that happen? Yes, it does. Did it feel that way with the BitBoy Crypto Atuzzi suit? Did it feel like Atuzzi was being wrongfully sued from my opinion and perspective? Yes. It felt like it was this is going to be expensive to you, so acquiesce to what I want. That's what it felt like to me. Does that happen? Yes, it happens. Do people try to use their money in the court system to silence people? Absolutely. Do I think that's happening here? No, I don't. And will I continue to say that this TikToker, if you do not have the money to play this game, maybe choose not to engage in this game. Not all fights are worth fighting. Could TikToker have ceded to the multiple cease and desists? Sure could have. Bluebell said the court can garnish her wages, though. I don't know what wages there are to garner. We need to check back in with the Cardi B, Tasha K lawsuit, because this is what Cardi B is going through, trying to get judgment from Tasha K. Tasha K was like, I'll file for bankruptcy. It is going to be years to recover anything in the Cardi B, Tasha K suit. And Cardi B is not, I don't think, going to recover 100% of what they got. The amount of recovery, Joe Neerman talks about this a lot because he had worked in this area of law. The amount of recovery that people get is so minimal compared to what is owed. Buttercup said TikTok wages. I don't think TikToker is still on TikTok. I think TikTok yeeted the TikToker off of TikTok. I don't think they're on TikTok still at all. So I don't think we are going to see a ton of a recovery here. Let us continue on. The court has personal jurisdiction over defendant. Let's find out how defendant ended up ceding their jurisdiction. Defendant argues the court did not have personal jurisdiction over her because she is a resident of Texas and her TikTok videos were published mostly in Texas, and accessed in several states. Absent personal jurisdiction, she claims the court's August 8th memorandum is void. To begin, oh boy, the court, buckle up, bitches. To begin, personal jurisdiction is a personal defense that may be waived or forfeited. Here it is. There it is. Even if defendant arguably preserved the defense within her answer, she nevertheless forfeited it when she substantially participated in litigation without first moving to dismiss under Rule 12b-2. Well, there it is. Footnote 2. Defendant does not specifically assert lack of personal jurisdiction as an affirmative defense. In the context of venue, however, she notes that she is a resident of Texas and that the publishing of TikTok videos took place in Texas. She still doesn't argue it right. The court is pointing out she still doesn't argue it right. Your lawyer would have known this, but you waived it. You waived it. She did not make a motion to dismiss under 12b-2. She answered the lawsuit first. And once you've answered, you have acquiesced to jurisdiction. It's done. And the court's like, to begin, you waived it. An objection to personal jurisdiction, for example, has been forfeited where, after properly preserving the objection in its answer, the defendant then fully participated in litigation of the merits for over 2.5 years without actively contesting personal jurisdiction. Indeed, oh boy, before the filing at issue, Defendant 1 affirmatively asserted counterclaims against plaintiff and attempted to add plaintiff's counsel as parties to the action. 2, submitted briefing and made oral argument relative to the merits of those claims in response to plaintiff's motion to dismiss and motion to quash. I attended that court proceeding. It was illuminating. 3, participated in the Rule 26F conference, stipulated to litigation deadlines moving forward, and filed a discovery plan. And pursued discovery from a third party via subpoena issued under this court's authority. Yeah, to Facebook. Remember that? Defendant's involvement in these discrete aspects of the case reveal that she has assented to the court's authority. You will heed my authority. Why? Because you agreed. You agreed. You can't undo it now. You said you agreed. You acceded that she has assented to the court's authority to adjudicate and correspondingly forfeited any challenge to the court exercising personal jurisdiction over her. You messed up on that one because you didn't make the motion the right way at the right time. Regardless, the court has personal jurisdiction. Regardless, the court has personal jurisdiction, specific jurisdiction over defendant. Footnote 3, we'll get there. Specific jurisdiction applies when the challenged act was purposeful, when the lawsuit arises from that act, and when the jurisdiction is reasonable. Citing Yahoo Inc. Each of those requirements is satisfied here. Footnote 3. Because defendant is domiciled in Texas, the court lacks general jurisdiction over her. Of course, if defendant was domiciled in Idaho instead, there would be no subject matter jurisdiction because complete diversity would not exist. Yes, did diversity jurisdiction exist in this case? If she was a resident of Idaho, no personal jurisdiction, no diversity jurisdiction would not exist, but then it would be a state court matter, not a federal court matter. Anyway. So, no. Purposeful direction, footnote 4. Purposeful direction, as opposed to purposeful availment, applies here since plaintiff's claims against defendant sound in tort, not contract. Purposeful direction. The touchstone purposeful direction requirement ensures that the defendant will not be hauled into a jurisdiction solely as the result of random, fortuitous, or attenuated contacts. To address this concern, courts typically inquire whether defendant's actions were felt, whether or not those actions themselves occurred within the forum. We're going to get to international shoe at some point in this, I'm sure. But did the TikToks reach into Idaho, and that's what he's getting for it? Was it felt? To address this concern, courts typically inquire whether the defendant's actions were felt in the jurisdiction. Where alleged tortious conduct takes place outside the forum and has effects inside the forum, our circuit has examined purposeful direction using the effects test. Under the effects test, a defendant purposely directed her activities at the forum if she, 1, committed an intentional act, 2, expressly aimed it at the forum state. And again, different than the Toddy Westbrook case, where Toddy was the one being discussed and Toddy's husband was the one being discussed. This case, even more specifically, talks directly about Idaho. It's talking about the Idaho University murders. It's talking about the University of Idaho. It's talking about a person that lives in Idaho. This one discusses Idaho even more than that case where it's talking about a resident who lives in a state. This is much more anchored in that state because all the conversations around the Idaho murders are about Idaho. And 3, causing harm to the defendant that the defendant knows is likely to be suffered in the forum state. Was this defendant unaware that the university professor plaintiff lived in Idaho? Doubtful, because the TikToker, by own admission, went through the University of Idaho's history department's website and found this individual. Is it reasonable to believe that somebody who works at a university in a particular state also lives in that state? Yes. Plaintiff's allegations, along with defendant's own allegations, meet the effects test. First, defendant admits she intentionally posted over 100 TikTok videos stating that plaintiff had a relationship with a student and then ordered the murder of 4 students to conceal that relationship from the public. Second, those videos specifically accused plaintiff, a University of Idaho professor and resident of Idaho, of having an affair in Idaho with a University of Idaho student and then killing the student and 3 other students of the University of Idaho in Idaho. Emily, keep reading. The requirement is satisfied when the defendant is alleged to have engaged in wrongful conduct targeted at a plaintiff whom the defendant knows to be a resident of the forum state. Third, taking plaintiff's allegations as true, defendant undoubtedly knew that, given that the accusations regarded alleged conduct by a plaintiff in Idaho, that the plaintiff resides and works in Idaho, any resultant harm would also take place in Idaho. If this plaintiff had caused this plaintiff to lose their job, the job would have been lost in Idaho. The reputation among the academic community would be most specifically felt in Idaho. The intense public interest and scrutiny and the people looking at you at the grocery store is all going to happen in Idaho. Because the effects test is met, so too is the purposeful direction requirement for specific jurisdiction. Plaintiff has therefore met her burden as to the first prong of personal jurisdiction. So we're going through all the prongs of personal jurisdiction. Great. Let's run the analysis. The court is not leaving anything open for discussion. The court is like, you waived it. But even if you hadn't, this is why it's here. Related to forum activities. Under the second requirement for specific jurisdiction, the plaintiff's claim must arise out of or relate to the defendant's forum-related activities. Plaintiff's allegations easily meet the standard. Plaintiff alleges that defendant's TikTok videos harmed her reputation and caused physical injury. Assuming that plaintiff's allegations are true, plaintiff would not have suffered injury but for the defendant's forum-related conduct. But for the TikToker talking about Idaho in Idaho and the University of Idaho, none of this would have happened. Plaintiff's defamation claims against defendant clearly arise out of and are related to the TikTok videos, conduct directed at the plaintiff in Idaho relating to matters taking place only in Idaho, the murders. Reasonableness. Once the plaintiff establishes the first 2 requirements of specific jurisdiction, the forum's exercise of jurisdiction is presumed reasonable unless the defendant presents a compelling case that the exercise of jurisdiction would in fact be unreasonable. That's Shoot versus Carnival Cruise Lines. This is the third and final requirement for specific jurisdiction. The Ninth Circuit has weighed in on this. 1, the extent of the defendant's purposeful interjection into the forum state's affairs. Did TikToker inject themselves into shit going on in Idaho? Chat? What say you? I say yes. 2, the burden on the defendant of defending the forum. 3, the extent of the conflict with the sovereignty of the state, of the defendant states. 4, the forum state's interest in adjudicating this dispute. Is Idaho interested in this dispute over shit that happened in Idaho with a person employed in Idaho? I think yes. 5, the most efficient judicial resolution of the controversy. 6, the importance of the forum to the plaintiff's interest in convenient and effective relief. 5, the existence of an alternative forum. Defendant has not seriously attempted. Wow. Defendant has not seriously attempted to meet this high burden, other than to mention in passing that she is from Texas and published her TikTok videos from Texas. But this is not enough to render jurisdiction in Idaho ipso facto unreasonable. To the contrary, it is reasonable for this court to exercise jurisdiction over defendant in this instance, as shown above. Plaintiff sufficiently alleges that defendant purposefully injected herself into Idaho-specific matters through her repeated TikTok videos. You inserted yourself into this mess. Come to Idaho and defend yourself. And while defendant no doubt will be burdened to some extent with having to defend herself in Idaho, she has done so to this point without any obvious hassle or impediment because the court's holding everything by Zoom. Lyndon said ipso facto unreasonable is my new fragrance. Steve said TikToker got ipso factoed. Modern advances in communication and transportation have significantly reduced the burden of litigating in another form. You caused the harm in Idaho. Come to Idaho and answer for it. There is no reason to believe that Texas has a particular interest in the case. Do you think Texas courts give any fucks about defamation arising out of a case in Idaho with a University of Idaho professor? Does the Texas forum care about this at all? Idaho has a strong interest in adjudicating the parties' dispute. Next, there are likely just as many witnesses, if not more, in Idaho as there are in Texas. Probably more, because they're accusing this woman. The defendant accused the professor of committing a murder in the state of Idaho. Aren't the witnesses generally going to be in Idaho? Making Idaho the most efficient and convenient forum for plaintiff. Finally, the existence of an alternative forum in Texas is not enough to counter the cumulative weight of the remaining factors. I appreciate that the judge was like, you waived it, but arguendo, here's also why we have proper jurisdiction. In sum, plaintiff has made a prima facie showing of jurisdictional facts, and all three requirements for specific jurisdiction have been satisfied. Thus, the court's exercise of personal jurisdiction over defendant comports with federal constitutional principles of due process, and the court has personal jurisdiction in this matter. Defendant's motion is denied in that respect. Venue. Let's go to venue. Generally, venue is proper, and an action may be brought in 1, the district in which any defendant resides; 2, a district in which a substantial part of the events or omissions giving rise to the claim occurred; 3, if neither is available, then any district in which the defendant is subject to personal jurisdiction. All three exist above. We're not going to get into that much more. The events occurred in Idaho. The defendant is subject to jurisdiction in Idaho according to the court, and the defendant or the plaintiff resides in Idaho. Defendant argues that since plaintiff claims to have not killed the students, the only event that gave rise to the civil action is the alleged defamation that occurred on social media, published in Texas and accessed in several states. Defendant's argument fails. That's the court. The court is out of words. The court is done. Defendant's argument fails. Period. Because there is no basis to conclude that the alleged defamation was felt anywhere other than in Idaho, venue is likewise proper in Idaho and in this district. Defendant's disagreement with the court's August 8th memorandum decision and order without more neither renders it void nor establishes a lack of judicial impartiality. You may disagree, but that doesn't change anything. The court's August 8th memorandum decision and order dismissed defendant's counterclaims against plaintiff and quashed the summonses. Defendant disagrees with the order and claims that it is void. This time, the sass. This time under Rule 60b-6, not Rule 60b-4, because it, quote, is obviously biased, one-sided, lacks in impartiality, and is likely maliciously motivated. The defendant wrote that about the court's order. The defendant said that the court's order was obviously biased, one-sided, and lacks in impartiality, and is likely maliciously motivated. Here's a tip, not legal advice, but a tip. Don't tell the judge that they are maliciously motivated without any evidence of such. If you were an attorney, you would probably be sanctioned at this point. Mm-hmm. Shit attorneys could never say. Could never say. She lodges the following objections to support her claim. 1, the court violated her First Amendment rights by ruling on the plausibility of her tarot card reading and psychic abilities. 2, the court contradicted itself and surpassed its authorities when weighing in on the plausibility of plaintiff's claims. 3, the court improperly left open the possibility of future sanctions. 4, the court improperly gauged the parties' interest in settlement negotiations. Defendant's argument is without merit. Defendant's disagreement with the court's analysis is not a basis for reconsideration. A party seeking reconsideration must show more than a disagreement with the court's decision, and recapitulation of the case and argument considered by the court before rendering its original decision fails to carry the moving party's burden. All of that. All of that. Moreover, the court's analysis, the defendant's disagreement relating thereto, did not support a finding of bias or partiality. Just because I ruled against you doesn't mean I'm biased. In sum, defendant's disagreement with this court's adverse rulings may represent a basis for appeal. They do not, however, justify voiding those rulings or establishing any bias whatsoever. Defendant's motion is denied in this respect. This court, the amount of restraint and judicial restraint being shown by this court, I find both admirable and annoying. I am ready for the court to start screaming, "Don't get brazen with me." Personally, I am ready to see someone get lit into. That's what I'm ready. I am rooting for the judicial smackdown that is coming. This is also why I'm not a judge. But this judge has showed a tremendous amount of patience and judicial temperament in not lighting into a pro per defendant who is wilding out in court. Would I like to see it? Yes. Is it going to happen at this point? No. This judge has shown tremendous judicial temperament, and I find that to be admirable. The petty side of me would like to see someone get roasted in some of these rulings. So we'll just add that part in. Because telling the judge that they are maliciously motivated is a level of fucking audacity that is staggering, when the judge, in a very patient and succinct way, lined out why it was the legally improper request. This judge has gone above and beyond to find the arguments that this pro per defendant is trying to make, and to said, look, you didn't quite make this argument. You didn't quite get there, but I am going to take the spirit of what I think you mean and give that due consideration. A lot of judges wouldn't. This judge has. And they're still getting called biased, and, because nobody on the internet has anything else to say other than they're biased. They're not. They just disagreed with you. It's not bias. It's just disagreement. Those two things don't have to be the same. Sometimes they are. Sometimes they are. Here, no. The court did not improperly judge defendant's religious beliefs. Oh boy. Oh boy. Oh boy. Oh boy. Defendant responded to plaintiff's defamation claims by going on the offensive, alleging that these claims, as well as statements made by plaintiff's counsel to the media and those claims, were themselves defamatory and purposely brought by plaintiff and her counsel to systematically deprive defendant of her constitutional right to free speech and due process. Certain of defendant's counterclaims reflected these beliefs, alongside related counterclaims for malicious prosecution and intentional infliction of emotional distress. Oh yes. Oh yes. Oh yes. This defendant said that there is no way that the university professor is emotionally distressed or has suffered any severe emotional distress from the TikToker's TikTok videos. But This TikToker went on in her counterclaims and answer and everything else to say that she is in fact a victim here, that she is the one who has suffered severe emotional and mental distress, and that severe and emotional mental distress has caused her substantial harm. Not that the professor could have ever felt those things, but that she was the only one that could have felt those things. Oh, yes. Oh, yeah. Oh, yes. Oh, yes. Together, these counterclaims presumed and depended upon an alternate version of events. That's a gentle way to say it. An alternate version of events surrounding the murder of the 4 University of Idaho students, namely that plaintiff orchestrated the murders and then colluded with her counsel to bring this action against defendant to silence her clairvoyant insight into the true extent of plaintiff's involvement. Damn, that's a good sentence. Okay, chat. I see your motions. Motion granted. Motion granted. Motion granted. Motion granted. Motion granted. We've celebrated this audacity before. We're going to do it again. I don't know if it's celebrated. We're going to call it out. We're going to call it out. We'll just code green it. We'll just code green it. I think motion granted. I keep forgetting to put a gavel sound on my soundboard, but we're gonna grant your motion with applause and go to the audacity. Chat, motion granted. There we go. We have gotten to the audacity of this situation. All right. Let's see. Diana said, can't file bankruptcy on a court judgment, can you? Yes, you can. You can file a bankruptcy on a court judgment. However, you will not always be granted a bankruptcy off an intentional tort. So, could it happen in this case? That's a long way away, but it is possible. Let's keep going. Now that we've gone audacity green, we're going to go back to the court's glorious retelling of the alternative version of events surrounding the murder, namely that the plaintiff orchestrated the murders, then colluded with her counsel to bring this action against defendant to silence her clairvoyant insight into the true extent of plaintiff's involvement. Miguelina, remind me, I need to copy and paste that for all future summaries of this case. It's fantastic. The court's August 8th memorandum decision and order dismissed defendant's counterclaims because there was, quote, no objective basis, in fact, to believe that the plaintiff did the things that defendant publicly and repeatedly claims she did. There are no facts. Defendant's, quote, intuitive abilities and, quote, spiritual acuity and, quote, investigative skills were not enough to allow the court to infer the existence of a plausible claim against plaintiff. You are lacking facts. Facts. Not feelings, not beliefs. Facts. Not fuckery. Facts. And while sometimes we love a good bit of fuckery, this is not the form for fuckery. That's why we watch reality TV. We keep our fuckery to the reality television of it all. Because the predicate components of defendant's counterclaims against plaintiff lack any basis in fact, those counterclaims should not proceed. At bottom, the court struggles to accept defendant's allegations as creating factually plausible counterclaims against plaintiff. Defendant takes issue with the court's analysis. Yeah. The defendant is like, Your Honor, you are denying my ability to practice my religion. She argues that because the court, quote, does not have subject matter jurisdiction over the plausibility of spiritual practices, the order on August 8th is void. Quote, the court, quote, this is the defendant saying this. The court is now quoting the defendant. The court intentionally erred in denouncing tarot readings and defendant's spiritual connection as a spiritual practice for the purpose of I forgot how glorious this motion was. For the purpose of overstepping the separation of church and state as required by federal laws and the First Amendment. Defendant's argument cannot succeed. The court is like, hey, law clerk, how do I find new ways to say no? Because this one is the defendant's argument cannot succeed. The other one was the defendant's argument fails. To survive a motion to dismiss, a complaint must contain sufficient facts accepted as true that, quote, state a claim to relief that is plausible on its face. Facts. A claim is facially plausible when the plaintiff pleads sufficient facts to allow the court to reasonably infer that the defendant is liable for the misconduct alleged. The courts generally construe pro se party filings liberally. The court may dismiss as frivolous claims that are clearly baseless. A category encompassing allegations that are, quote, fanciful, fantastic, and delusional. At some point, are we going to see court filings that just say Delulu? I think we might. Your Honor, cap. The amount of times I've been tagged in the Gen Z lawyer memes. I love them. Your Honor, my client's a Sagittarius. Fanciful, fantastic, and delusional. Mama Bear in the chat said, did he just call her delusional? No. The court is quoting case law that says that though courts are very lenient with pro se filings, courts will give non-lawyer defendants quite a lot of leeway. But even with that leeway, the court cannot sustain clearly baseless claims. And clearly baseless claims include claims that are fanciful, fantastic, and delusional. Under Denton versus Hernandez from 1992. As those words suggest, a finding of factual frivolousness is appropriate when the facts alleged raise to the level of the irrational or wholly incredible. From Nietzsche versus Williams, the term frivolous, the court's not done. Did the court have to go this deep into it? No. Is the court going there? Yes. The term frivolous applied to the complaint embraces not only the inarguable legal conclusion, but also the fanciful factual allegation. In this context, claims that are clearly baseless are not facially plausible. Here, defendants' counterclaims were supported only, in italics, by her spiritual intuition. Not objective facts. When I attended this court hearing, and it was by call-in, so when I listened to this court hearing, the court asked repeatedly for objective facts. At one point, this defendant, TikTok psychic, said, I did not see that question coming. I've never been more glad to be on mute. But the court asked repeatedly, what objective facts do you have to support your belief? Your Honor, they could have known each other. Could have is not an objective fact. I feel like we need to go the entire internet, not the law nerds, the rest of the internet. We need to get back to what is a fact, what is opinion, what is speculation, and where those things are and are not appropriate. Because sometimes facts are things we don't like. There are plenty of facts I do not like. It does not make them not the facts. And I feel like as technology advances, it is getting harder and harder and harder to parse fact. And I feel like, I could rant forever. We need to get into and back to, these are things that are facts. These are things that are opinion. These are things that are speculation. And you can dislike those things, but it does not invalidate them. Here, defendant's counterclaims were supported only by her spiritual intuition. But intuition, even if summoned by one's spirituality, does not make a legal claim plausible. What? Intuition, even if summoned by one's spirituality, does not make a legal claim plausible? Your Honor. No. Of course he's right, and in a patient and elegant way, stating it. Otherwise, there would be no standard against which such claims could be tested under Rule 12b-6. Yes, we stopped doing this with the witch trials. We don't just go, but Your Honor, I feel like they did it. Maybe we can go, Emily, don't get into the Monty Python witch sketch. Don't. It's dangerous ground. It's because Monty Python didn't used to be dangerous ground. But my brain, if you all have not seen Monty Python, or at least the witch sketch, now is the time. Becky, she turned me into a newt. A newt? I got better. Thank you, chat. I got better. Look. We need factual-based evidence. And sometimes that means that wrongs go unrepented for in court. That sometimes there are things that just cannot be proven. And so justice in court is not obtained. It happens. But there has to be some standard of objective fact that we rely on in court. There has to be some level of fact and testing of facts and determining facts. And this judge has been very, very patient in saying, look, intuition is not fact. It's your feelings. And it does not have a place in this court. Otherwise, there would be no standard against which such claims could be tested under Rule 12b-6, and asserted First Amendment protections would automatically insulate affirmative claims from dismissal, while conversely protecting actionable conduct as well. This is not the standard, nor can it be. First Amendment permits restrictions on false statements of fact harming another's reputation. False and defamatory statements of facts we have held have no constitutional value. Your First Amendment right does not mean you have the right to say shit which is defamatory. Your constitutional rights do not protect you if you commit harm against others, either criminal or tortious. At bottom, the court loves saying at bottom. At bottom, claims must be based in fact, not conclusory and unverified beliefs. With that standard in mind, the court simply held that absent objectively verifiable factual allegations, defendants' counterclaims were implausible. Nothing more, nothing less. But the court did not stop there. The court's now referring to the court in the third person. But the court did not stop there. It went on to explain, with tremendous patience and at great length, how each of defendants' counterclaims against plaintiffs is also legally deficient. The court didn't just yeet this. The court went on and on and on to do it. And on and on and on. And it goes on and on and on. I feel it coming in the air tonight. And now my brain is conflated between the original song and the Captain Sparkles Minecraft version of the song. Damn it. The ADHD is strong today. In other words, defendants' counterclaims were not dismissed only because they were deemed implausible. Each counterclaim distinctly failed as a matter of law. You lose on two fronts. These merit-based shortcomings separately undercut defendants' argument that the court's memorandum decision and orders are void for impermissibly commenting on the plausibility of defendants' spiritual practices. You can do whatever you want spiritually. What you can't do is defame people. Defendant's motion is denied in this respect. Plaintiff has stated a claim for defamation. Defendant lastly argues that plaintiff's defamation claims against her should be dismissed because 1, Idaho's judicial privilege covers her statements made in her TikTok videos. I said that right. I continued to read that correctly.
The TikToker argued that Idaho's judicial privilege covered the TikToker's statements made on TikTok. That judicial privilege is a TikTok privilege. That shit you say on TikTok is just privileged by magic, by magic.
And 2, plaintiff has not adequately stated a claim for relief. Let's get into the judicial privilege. First, Idaho's judicial privilege immunizes a party from civil liability for statements made in the course of judicial proceedings. Idaho has long recognized that defamatory statements made in the course of a judicial proceeding are absolutely privileged. This is true in all jurisdictions that I'm aware of. And this is why some might choose to make claims. I talked about this in my podcast episode covering Cassie's lawsuit against Sean Combs. This might be the reason to choose a lawsuit. Of course, a lawsuit has to have basis, right? But this might be the reason to choose a lawsuit over a podcast interview, a book, a video, an op-ed, whatever. Because statements made in the course of a judicial proceeding are privileged, even if they could be determined to be defamatory, even if made with malicious intent or knowledge of their falsity. There are separate procedures under the law in court to deal with statements like that. The purpose of the judicial privilege is to keep the paths leading to the ascertainment of truth as free and unobstructed as possible. This privilege sets a low bar, requiring only that the defamatory statement, 1, be made in the course of a proceeding, and 2, have a reasonable relation, the cause of action to the cause of action of that proceeding. Defendant's TikTok videos do not satisfy this standard. Obviously. Because they were made well before the cease and desist were sent, before the lawsuit was filed, before there was a judicial proceeding. Something can't be in the course of a judicial proceeding because you foresee that a judicial proceeding might be coming. It has to be in the course of a judicial proceeding. Which is also why people covering a judicial proceeding, if they accurately reflect what is in the filings by reading the filings and say, the filings say this, can't be sued for defamation. So good luck trying to sue Marquis and Atuzzi. No, don't try to sue them. It's just a waste of your own money and time. Because what they've said is that the court filings say this. Defendant's TikTok videos do not satisfy this standard. Yep. To be clear, the court's going to keep going. To be clear, a judicial proceeding in this context is not limited to trials. It includes every proceeding of a judicial nature before a court or official clothed with the judicial or quasi-judicial power. Where is our robe? The robe of righteousness from South Carolina. Bring me South Carolina's robe of righteousness. Defendant's TikTok videos were never made in any proceedings that could be understood as judicial in nature. No, they were made on TikTok for clicks and views. And while statements made to law enforcement may be subject to qualified privilege, defendant's TikTok videos existed independent of any criminal investigation into the murder of the 4 University of Idaho students. That is, the alleged defamatory statements embedded within defendant's TikTok videos were not relayed just to law enforcement as part of a discrete criminal investigation into the murders. Had you called the tip line and said to the police, hey, that might be limited and different. But that's not judicial privilege either way. Chat, you guys are cracking me up. You mean TikTok isn't court? Missy, that's what the judge is saying. That seems to be what the judge is saying. Mm-hmm. 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 Instead, they were effectively disseminated worldwide. That statements may also be communicated to law enforcement does not immunize them, particularly when no charges have ever been brought against plaintiff. Second, defendant's insistence that plaintiff has not proven her defamation claim misunderstands plaintiff's burden. Oh, Your Honor, that is such a gentle way. That is such a gentle way to say it. The court is telling the defendant that that is not the law, ma'am. That's not what we're doing here. The standard at 12b-6 is not the standard at trial, and you are wrong here. You should have asked your attorney, and they could have maybe explained it to you, and the judge is kind of taking on the role of explaining it in a patient and well thought out manner. Second, defendant's insistence that plaintiff has not proven her defamation claim misunderstands the burden at this phase of the proceeding. At the motion to dismiss phase, plaintiff need not prove anything. It is based on the 4 corners of the document and whether or not it is sufficiently pled, and that is it. She needs only allege facts that, if true, plausibly support a claim. That is all. Twombly. Law students everywhere are like, oh. Plaintiff has done this. She has alleged that defendant made false and defamatory statements implicating plaintiff in a relationship with a student and the murder of 4 students. That defendant knew her statements were false, that plaintiff was damaged as a result. The end. These allegations support a defamation claim under Idaho law. A motion to dismiss is not the proper legal mechanism for substantively challenging these allegations. That is a function of either a motion for summary judgment. Don't tell her, Your Honor. The court is so kind. That is either a function for a motion for summary judgment or eventually trial. Until then, defendant's motion is denied. Your Honor, you've not yet granted legal fees. Based on the foregoing, it's ordered that defendant's motion to set aside and dismiss is denied. Footnote 6. Plaintiff once again requests that the court exercise its inherent power and award attorney's fees to plaintiff. For reasons already articulated, the court declines to sanction defendant at this time. Are we getting close to the time? Are we getting close? Are we close to the time? Your Honor, how close in time are we? Because at some fucking point, this has to happen. Guess what, you guys? We're not done yet. So, defendant, TikToker tried to have all of the motions set aside and did a motion to dismiss all the things. Denied. The complaint is going forward. But we have other litigation happening, and the other litigation happening is the plaintiff's motion for summary judgment. And the TikToker has responded to that motion. So let's go to the motion for summary judgment, shall we? Oh, it's a lot. Let me find the, did I not do docket 50? Some of the defendant's reply that we covered for the court, I did not do. Maybe we'll have to go back and cover the defendant's reply. It looks like I didn't cover it. All right. As a quick refresh, here's a quick road so far. Here's a quick road so far. Also me, glitching. Here's a quick road so far. We've got to reset the lights because we haven't reached the audacity yet. We have nowhere to go if we don't reset the lights. We have to go to a new motion. Don't worry, Audacity. We may be back. We may be back. Here is the briefest summary, I think. Memorandum in support of plaintiff's motion for partial summary judgment. Plaintiff professor requests that the court enter summary judgment on behalf of her claims against TikToker as a matter of law and as consequence of her failure to engage in this litigation as required by the federal rules of civil procedure. TikToker has admitted to defaming the professor. TikToker's admissions establish beyond dispute that TikToker is liable for defamation of professor. Accordingly, all that remains is for a jury to determine the damages. The TikToker failed to answer any of the discovery questions, requests for admissions, etc. As a matter of law and federal procedure, those things are deemed admitted. Because those are deemed admitted and the deadlines have passed, the plaintiff professor came in and said, Your Honor, the TikToker has admitted liability. So because the TikToker has admitted liability, we just need to have a trial on damages. So go ahead and grant the motion for summary judgment. The motion for summary judgment would establish liability for the defamation. And then all a jury has to decide is how much. That's it. So we're going to go to, let's see, that was the partial motion for summary judgment. Let's get to the defendant's response to that partial motion for summary judgment. Hold on. This is the TikToker in pro se. You will notice that there are no numbering on the side of the page. So we're there. We're there. We're there. Comes now defendant TikToker in opposition to plaintiff's motion for partial summary judgment, docket number 56. This litigation is a matter of determining the truth of the matter. Whether or not the professor caused the murder of 4 University of Idaho students found slain November 13th, 2022. You've misstated the purpose of the litigation, though. The purpose of the litigation is to determine whether or not the defendant defamed the professor by making these allegations. So we're missing a bit. Okay. It's also important to determine if the court has subject matter jurisdiction over the plausibility of spiritual beliefs and practices, which was brought into question by docket 50 on August 21st, 2023. This was filed on Halloween. Hold on. When was the court's order? The court's order was filed on November 13th. So remember I said I was out of time order a little bit. This response from the defendant comes before the court's order that we just read. So that's why it's coming up again. In case you're like, wait, didn't we just settle that? Yeah, yes. Lastly, it is important to determine if spiritual messages give rise to a cause of action for defamation. It's not the messages that are the problem. It's the saying them on the internet as fact that's the problem. None of the above has been determined. Additionally, defendant TikToker has never admitted to defaming the plaintiff. Instead, she has continuously argued that this litigation was brought illegally in bad faith to avoid professor from being properly investigated for ordering the murder of the victims. This litigation has been complicated by the courts and the public's ignorance on the plausibility of tarot readings, spiritual connections, and spiritual beliefs. I did not have the defendant calling the court ignorant on any bingo card ever. I don't know what's worse. Calling the court malicious or calling the court ignorant? We need another poll. I know some of you won't be able to see them. I don't know why polls are glitching. I'm sorry to those of you that are having glitches on the YouTube end, but I have to. Also, with the poll that we just ended, you'll be able to see the results. If you are on the jury, how much are you awarding? 33% over $1 million. 28% the limit does not exist. 9% under 75,000. 28% over 75,000. But this is a matter of your opinion. Which is worse? Calling the court malicious, and biased, or ignorant? All right. Chat, the poll is up. You tell me. Calling the court malicious and biased or ignorant? Which one's worse? Mike said, is it wrong that this is my favorite case since Colin? No. No, it's not. No, it's not. There is no judgment here. Because there's some shit you just don't see every day. And this is part of it. This litigation has been complicated by the courts and the public's ignorance on the plausibility of tarot readings, spiritual connections, and spiritual beliefs. Defendant TikToker has evidence that she and her spiritual messages are reliable sources. That's not the evidence you need, though. For example, TikToker conducted an intuitive tarot reading for someone on March 8th, 2023. It predicted the upcoming death of the person's husband who was otherwise healthy and young. What the fuck? Also, I have friends that do tarot. I do not hate tarot readings. I do not hate spiritual intuitives. I am not mad at any of this. What you can't do is use whatever tools you may have to defame people. There is an ethic to it. But the evidence that this is not I am flabbergasted. Chat, help. Chat, my brain is buffering. For example, TikToker conducted an intuitive tarot reading for someone on March 8th, 2023. It predicted the upcoming death of the person's husband who was otherwise healthy and young. Although the defendant hoped it wouldn't come true, the husband died on October 24th, 2023. See Exhibit A that predicted the death of SSGP Keanu White. What is this footnote? A Facebook post, 2 Facebook posts, and a YouTube video. The TikToker. Oh, it's a link. Hold on. I'm going to make sure it doesn't pop up anything that YouTube would be mad at. This pops up a 29-minute tarot reading that is an unlisted video with 39 views from 8 months ago. So this is an unlisted video. I don't know if this was hired to a client or whatever, but she is trying to list the fact that she predicted someone's untimely death as evidence that her intuition is factual. That's an analogy. I need to look at the Facebook post. the Facebook post that she pointed to shows nothing other than an individual who is in the Army. But and the posts that she is posting are some people discussing what seems to be the passing of an individual by taking their own life. So I am not going to pull up any of these Facebook posts, but I wanted to understand more in context of what was going on. Okay. She is claiming that she predicted the passing of this individual 8 months before it happened. And that is the evidence that the court needs to take as true, that she could predict accurately that the professor did what she says, and therefore it's not defamation. All of this is breaking my brain. And it feels predatory to me. This is my feelings. This is not legal analysis. This is Emily's feelings, to list this person's whole life and video in this public court filing, and I am not going to dive into it anymore. It feels intrusive. It goes on to argue, thus, because TikToker has experienced confirmation of the reliability of her intuitive tarot readings for the past 4 years, she has reason to believe that the messages she received about Rebecca Schofield are substantially true. That's not how this works, though. That's not how any of this works. Oh, I hate this so much. Okay. Saying that you have predicted something correctly and therefore it should be evidence in a court case that you did not commit defamation is not going to fly. Analogies are not evidence. Second of all, whether or not you believe what you're saying is a whole different thing. Her arguing, I believed this was true, is a whole different circumstance that is not at all related to what is being argued by the plaintiff. And it's so far out of left field that I am having a hard time reining myself back in to what is being argued here and not going off on a rant, a galloping rant about this. I am trying to stay focused. It is hard. Okay. Vincent, help me. Vincent, we're going to let it out one more time. Okay. And we're going to move on. The plaintiff is arguing that the defendant's failure to respond to discovery is under the code and admission to all of the things that she was asked to answer in the interrogatories, and therefore she should be deemed liable. She is arguing that she predicted something else with someone else unrelated to this lawsuit, and therefore nothing else matters and that the court's ignorant as to spiritual practices. Oh, chat, I see the motions for code red. Yeah, we're there. We're there. We've gone from green to red. We're there. Yep, we're there. I don't know if there's any greater fuckery than this. And she put somebody else's business out here, which I fucking hate. It's not, it doesn't even begin to cover or respond appropriately to this. Okay. For those of you that are new to the chat, hi to the YouTube things. Code red is flashy. It will stop flashing when the music stops. So if you are flash sensitive, be mindful that the flashing stops when the music stops. We are going to code red in 3, 2, 1. And for those of you that are newer to my channel, hi, I appreciate you. Code Red is our DEF CON what the fuck. We had a whole DEF CON rating system, and we've kind of gone from a full DEF CON rating system to Audacity and what the fuck. We've kind of narrowed it down to the two things that we use: DEF CON Audacity and DEF CON what the fuck. Robin, the ADR Pro, I should ask Aphrodite. I should ask Ant what he thinks. Like, Ant, what about this? He's like, I don't want any part of that. But this defendant takes every single opportunity to wild out in court documents. That's true. We do have a code cat, Code Fred. Code Fred gets used sometimes. In the winter, Code Fred is curled up on the couch in a blanket. I need to put the blankets back here so the cats can come cuddle up in here. Okay, let's continue, shall we? Schofield and her attorneys have continuously lied about TikToker in every legal document they've filed in this civil complaint. Explain more fully below. Oh, do tell me. For example, in docket 56, plaintiff's motion for partial summary judgment, attorney Wendy Olson made a false statement that defendant Ashley, or defendant TikToker, posted content about the murder of the students to quote unquote make money. Attorney Olson published that lie about TikToker knowing it was false because she has documents from TikTok provided to her after a subpoena dated June 20th, 2023, proving that defendant did not make any money by posting content on TikTok. Attorney Wendy Olson also promulgated several lies that about TikToker in multinational news media. I would love to be a fly on the wall as this law firm tries to deal with this, because this would be one of those things where I would just be like, everybody in the conference room, we're walking through this together. We're walking through this together. TikToker, in other filings, TikToker is now arguing against herself. TikToker in other filings has alleged. Do I want to pull up the filings? Do we have time to pull up the filings? No, keep going. Stay focused, brain. TikToker has alleged in other filings that the statements of this attorney have cost her money and ruined her reputation because she does private readings and because she does other types of things. So her TikTok, even if she's not getting paid by TikTok, her TikTok is marketing for all of those other services. And she alleged that her reputation and finances were damaged by the things that this attorney said. So if this attorney says that you were posting to make money, how is that false when you said that the attorney saying these things about you caused you to lose money? Make it make sense to me. Attorney published the lie that TikToker published that lie about TikToker knowing it was false because she has documents from TikTok showing that the TikToker was not making money posting on TikTok, but she still has a website where she will take your money for readings. Additionally, TikToker has reason to believe that this entire complaint was filed fraudulently and frivolously. The court does not believe you. As a matter of law, here, those words do not mean what you think they mean. As a matter of law and as punishment for continuous judicial misconduct, what? We're only on page 3. As a matter of law, and as a punishment for continuous judicial misconduct and several perjurious statements and documents, defendant requests the court deny the plaintiff's motion for summary judgment and to heavily punish the plaintiff and her legal counsel with sanctions. Whose judicial misconduct? Do you want the court to punish themselves? What is happening? I'm just relevant background. Factual history. The court said it wasn't factual, so the court has determined this is an alternative version of facts. Asterisks. The court has determined that the court has proffered that this is an alternative version of facts, and alternative version of facts do not necessarily have the grounding in objective reality. On November 13th, 4 students at the University of Idaho were murdered at a home near campus. That is an objective fact. On November 23rd, upon request of a TikTok user, TikToker began conducting intuitive tarot readings to get answer on who, what, and why, and how the 4 students were murdered. The intuitive reading revealed that, warning, the intuitive reading revealed that professor hired a male student to murder the 4 students. During the evening of the murders, she sent another male to make sure the murders were committed. Ultimately, one of the men left because the original male took over the situation and committed the murders. Professor hired the men to kill the students to protect her reputation. She feared she'd be exposed for having an affair with one of the female victims. On November 28th, TikToker received a demand letter by email demanding she cease posting videos about Professor. TikToker refused to follow the demands. That is an objective fact. TikToker refused to follow the demands because she believed she was telling the truth, and she was protected by the substantial truth doctrine of the First Amendment of the United States of the Constitution. That's not how that works. If you're trying to say that you are defending your defamation claim by saying that it is true, you are going to have a long way to go to try to prove that any of this is true. Notwithstanding the fact that TikToker believed that she was telling the truth, on December 21st, 2022, Professor and her attorney illegally filed a frivolous complaint in the District Court of Idaho. They subsequently lied on They subsequently lied on TikToker in every legal document they filed in the complaint to prevent the professor from being suspected and investigated for the murder of the 4 students. Okay. Recent history. Those were the factual history. Now the recent history. In the discovery phase of the litigation. Oh, no, it is the discovery phase of the litigation. Great, thank you for orienting us. To prevent defendant from obtaining physical evidence, the plaintiff and the attorney filed a motion to quash the summons that professor served to Facebook. Yes, it was improper. Additionally, a motion to dismiss the complaint due to fraud, lack of subject matter jurisdiction, and lack of personal jurisdiction is pending. It is no longer pending. It has now been denied. The motion for partial summary judgment was improperly filed while the defendant sought evidence and due process. False. The motion was filed with the intent to impede the due process for Gouliard. No, it's just following the rules. Ask your attorney. Legal standards and argument. Oh, please tell me more. Substantial truth is a defense. Professor has not proven that the statements that the TikToker made about her were false. The complaint and subsequent filings, the court has reiterated that you misunderstand the standard at this point in the proceedings, and that is a gracious way to say it. The complaint and subsequent filings by the plaintiff relied on the court to ignorantly deem. She called the court ignorant twice. Lemon Drop, does she have an attorney now? No. No, she's her own attorney. The complaint and subsequent filings by the plaintiff relied on the court to ignorantly deem TikToker's spiritual practice as implausible. No, they've said nothing about your practice. They've just said that you need to have like evidentiary support for your claim. That's what they've said. Though the court did say that the court did drop the word delusional. However, as proven by Exhibit A, that was mentioned in the introduction, TikTokers' intuitive messages are reliable. Exhibit A is an intuitive tarot reading conducted by TikToker at the request of a concerned wife. She wanted insight on her marriage and the potential threat of divorce. Even though we did not ask, the reading revealed that the husband was about to die and that the wife would not expect it. Unfortunately, 7 months later, her husband died by self-harm. And then again to the TikTok posts. TikToker received confirmation of the reading from the wife as she was seeking more answers pertaining to her husband's death. TikToker has evidence of the accuracy of her intuitive tarot readings. None of this is relevant. None of this is relevant. It's just none of this is relevant. I can't imagine how exploited this individual feels by having this blasted in a public court filing. This poor family. But this TikToker is going to do whatever they need to do, it seems, to defend themselves and say to the court, look, I said this thing would happen and this thing happened. Therefore, obviously, I didn't defame this professor. These things have nothing to do with each other in a legal sense. Stop it. And leave this family alone. But she's using it as evidence of the accuracy of her readings. They cannot be deemed as implausible on its face. They said you need like evidentiary support. Something else happening is not evidentiary support for these claims. Therefore, it is possible. Possible is not the standard. It is possible that the messages TikToker received about Schofield is likely to be true. Possible that it's likely to be true is not the legal standard here. Because criminals are likely to lie about their crimes, the truth is a matter of time, resources, and discovery. What? Okay. In alignment with typical criminal behavior. Oh, please tell me more about typical criminal behavior in your civil suit responding to a motion for summary judgment based on the fact that you didn't answer discovery. Please, let's tangent a bit more. In alignment with typical criminal behavior and intent to hide their involvement in crimes, the plaintiff and attorney has blocked discovery attempts to get evidence regarding the connection Schofield had with the victims and with the alleged co-conspirators of the murders. No. They also omitted information from the University of Idaho subpoena. The attorney strategically omitted requests for all communications between the professor, the 4 students, and alleged co-conspirators. Instead, she only sought communication that Schofield taught a class that the students were enrolled in. TikToker has not alleged that. And communication regarding an investigation. Gouliard has not alleged that. Due to the strategic lies, omissions, misinformation, and manipulation by the plaintiffs and their counsel, TikToker must subpoena the university for the correct information. Subpoena it correctly and you'll probably get it. It is still a matter of discovery and investigation to expose the communication between the professor and the 4 students and alleged co-conspirators. The document provided by the University of Idaho admits they never investigated the claims. Professor has not proven that the statements TikToker made are false. That's not the standard. And that's not even what you're trying to defend against in this response. You have missed the point entirely. This is not your moment to defend your case. This is your moment to deal with the motion for summary judgment, and you are not even addressing the motion for summary judgment at all. We have wandered off into the woods alone on a new moon and are lost. That is all. That is it. I want to know what her tarot reading on this case has said. I want to know what her readings on this case have said. Truly curious. Okay, keep going. Let's keep going. We're going to try to rein it back onto the tracks here. The standard has been missed. Furthermore, plaintiff and their attorney strategically blocked TikToker from evidence that the statements she made are true. Law is a game of strategy. And I know that legalese is hard, but law is a game of strategy. That's the thing. And yes, they're going to block any fishing expeditions. Subpoenaing Facebook for all is not going to work in any court, with any attorney, and with any judge. Therefore, the plaintiff fails to prove defamation, which requires a false statement to be made. That's not even the question here. Bruh. Schofield fails to meet elements 2 to 3 of a defamation claim. We're not even having that conversation. We're not trying to prove defamation. This is a motion for summary judgment because you failed to participate in discovery. Oh my God. This is why we're only doing one topic today. The elements of a defamation claim applicable here are as follows. No, not applicable here, just in general. The elements of a defamation claim are, what are you citing? What case are you citing or trying to cite? Citing Go versus Tribune. You could have just cited back to the court defining this. That there was a communication to others, the information was defamatory, and there was damage. Professor and attorney failed to prove that the statements are false. You continue to misunderstand the standard here. Therefore, they have not proven defamation required by the second element. That is not the question. Additionally, Professor admits to not being investigated by the university or the police department, nor has she proven any damages to reputation. Not relevant. She has not lost any wages, employment, or opportunities. Not relevant. Instead, she has gained in popularity. Also not relevant. Thus, Professor fails to meet the third element, which requires reputational harm and damages. Therefore, the request for summary judgment must fail. That is not the question here. You continue to misunderstand the question. We are not at the factual defense part. You are defending against a motion for summary judgment based on your failure to participate in discovery. And you haven't addressed that yet. The complaint is barred by qualified privilege. How? TikToker conducted a psychic investigation and exposed the results online because she wanted to help solve the murders. An intuitive reading revealed that Professor would get away with murder if TikToker did not get involved. You see yourself in a very grand position, it seems. Therefore, TikToker posted the information she gathered from the intuitive tarot readings online for exposure. Well, that does help the plaintiff prove that you published the statements and that the goal in publishing them was for more exposure. TikToker did not know how she could make a positive impact on the case of the murder of the 4 students as an outsider. She posted the content with the intent to gain exposure. That's very helpful to the plaintiff, so that she could get the attention of the investigators and help solve the case. So her goal was to get the plaintiff arrested. The judicial privilege immunizes a party from civil liabilities for statements made during judicial proceedings. Please show me the judicial proceeding that was happening here, because the police investigation was not a judicial proceeding. But the court already addressed that, denying your motion. Laura in the chat said she could have made a phone call. Oh, she did that too. She definitely called the tip line with all of this. She did. She did do that too. She did that as well. Defendant TikToker's statements about professor's alleged involvement in the murder of the students were made during judicial proceedings. Wrong. Specifically during the investigation of the murders. Incorrect. No. Yes, the statements were made during that time. No, that is not a judicial proceeding. That is not accurate. Wrong. But TikToker's statements on TikTok warranted the Moscow Police Department to make and issue a statement that there is no evidence connecting this professor to these murders. It garnered enough attention that the police department had to make a statement about it. Woof. Although TikToker is not a party in the criminal case, she sent her findings to the FBI tip line as a witness to help solve the case. Well, a spiritual witness to help solve the case. Therein, her statements easily meet the standard of judicial privilege. False. And the plaintiff fails to state a defamation claim. Also false. That's just wrong. I don't know how else to say that's wrong. The court explained it well. Statements to law enforcement for the purpose of investigating or initiating criminal proceedings are entitled to qualified privilege for all torts except malicious prosecution. Qualified privilege and judicial privilege are different, and you publish them on TikTok. Calling the tip line is different than calling an FBI tip line and publishing things to TikTok are not the same thing. Therefore, it says, the defendant's statements on social media are also privileged due to the reasonable relation to the pending criminal case. No. Thus, the complaint fails to state a claim for relief and must fail. It's also in the interest of justice to dismiss the complaint. That motion's been, you've made that motion in another motion, and that motion has been denied. Fraudulent litigations are not entitled to respect. I do these as first looks because we need to go on this journey together, and I cannot go on this journey by myself. But the heading fraudulent litigations are not entitled to RESPECT is fucking sending me. What is happening? Fraudulent litigations are not entitled to respect. I don't know. I have seen a lot of things in my almost 18 years as an attorney. I have done trials with pro per defendants. This is unique. This is okay. Okay. Chat, there it is. Your Honor, this cause of action is not entitled to respect. No cap. I rest my case. That's it. We're done. We're all done. We're done. That's it, Your Honor. That's it. The plaintiff's argument that TikToker's lack of response. Oh, wait, we're actually getting to the point. I got so thrown off by the headline, but we're actually getting to the point. This is the point of the motion for summary judgment. Look at this. The plaintiff's argument that TikToker's lack of response to the request for admission conclusively establishes the material facts. That is the correct argument. We're there. Look. This TikToker cannot argue that they don't understand because it's right there. That is exactly what this motion is about. That. And it's not that they're arguing it. It's that the Federal Code of Civil Procedure also allows for it. You know, that picky little code. Stick to the code. This is an argument. However, TikToker has not received the requests. That's actually an argument. That is a valid argument. That we've now got, look, we're at subheading D. We've gotten to the D, and this is a valid argument. That's fair. If you did not receive them, then how can you be held responsible for failing to respond to them? Look, we found an argument that's actually a helpful one. To date, she is not sure if it was sent by email or mail. Allegedly, it was sent June 20th, 2023, when TikToker was in New York. But where? They should have asked your spiritual guides where you were, I suppose. The plaintiff likely failed at properly communicating with TikToker at an attempt to get a default judgment. That's a big accusation. And that's a lot of exposition in that accusation. The plaintiff likely failed at properly communicating to get a default judgment. That's not what's going to happen, though. But that's an argument. You should have led with this. Lead with this. Your Honor, they're trying to seek a motion for summary judgment based on a failure to respond to requests for admissions that were never communicated. Just go with that. Leave the rest of it out of it. TikToker believes the complaint and subsequent filings are fraudulently filed. No. Back up. Back up. These sentences, this is it. Stay right there. You live here. Your argument is here. You just live here. Stay there. That's it. We are 7 pages in and we have gotten to, but Your Honor, I never received them. Now, I imagine the plaintiff is going to have something to say about that in their reply, but that's at least an argument. TikToker believes the complaint and subsequent filings are fraudulently filed. So what? She also believes the judicial proceedings have lacked in due process and judicial impartiality. The court's thrilled with that argument, by the way, and are entitled to no respect whatsoever. Oh, fuck. Remember when the judge said, what was it that the judge said? That their tolerance for fuckery in these proceedings was low? This isn't going to go well. Your Honor, these judicial proceedings have lacked due process and impartiality and deserve no respect whatsoever. No respect. Your Honor, you are not entitled to any respect. For everyone who said Rodney Dangerfield has entered the courtroom, yep. I think we've completed the fuck around. Yes, chat, I think we've completed the fuck around. Little hard to say you didn't get them when publishing a TikTok about using the legal notices as toilet paper. Also fair. Girl, You are in danger. In Griffin versus Griffin, the defendant alleges that a pro se litigant won his case in the Supreme Court who stated, the Supreme Court stated, quote, a void judgment is a nullity from the beginning and is attended by none of the consequences of a valid judgment. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights. I don't think these two things are going to work the way you think they're going to work. TikToker believes that Professor ordered the murder of 4 students and filed this illegal complaint against TikToker to avoid suspicion. Professor and her attorney used the court and news media to humiliate TikToker, mock her spiritual beliefs, and lie on her in every filing. I am reading this verbatim. She then quotes all the filings. In the complaint, attorney made a false statement that TikToker decided to use the community's pain for online self-promotion. The truth is that TikToker used her talent to find out what happened to the 4 students and others. Okay. Professor and attorney made a false statement that Professor never had met any of the victims, let alone entered a romantic relationship with them. This is not an undisputed fact. It is a matter of discovery. However, attorney did not ask the university to investigate or provide the communication proving this to be true. What? In docket 49, the court joined in the disrespect. Danger. In docket 49, the court joined. I wonder what she thinks about the newest order. In docket 49, the court joined in the disrespect of TikToker's spiritual practice and beliefs, erroneously calling it implausible. During the court hearing, the judge empathized with Schofield and asked Gouliard to consider how Schofield felt, notwithstanding the fact that TikToker believes Schofield to be a quadruple murderer. That's not exactly how this went down. The frivolous complaint, perjurious filings, and lack of judicial impartiality, coupled with the court's lack of jurisdiction, deemed the entire complaint void. Therefore, TikToker was not legally required to participate in the plaintiff's fraudulent attempts to harass her. Oh, Your Honor, I didn't get them. But even if I did, I'm not required to respond because this proceeding is not entitled to respect because they are lying on her name. And she said, this whole thing is void. Wrong. That's wrong. The plaintiff's argument for summary judgment must fail unless the order is for a complete dismissal of the complaint. That's not on the table. A complete dismissal of the complaint has been denied. That's not on the table. The argument for summary judgment is against you. The complaint does not meet the standard for a summary judgment. What? The plaintiffs have blocked discovery attempts for TikToker to gather evidence. Ergo, the litigation is at an impasse and it's not at an appropriate time for a decision. Okay. Additionally, TikToker alleges that the plaintiff and attorney lied in every docket they have filed with the court. You're going to have to prove that. TikToker also believes that the statements she made regarding the relationship with one of the students and regarding the professor's involvement with the murders are substantially true. Therefore, the plaintiff fails to meet the requirements of the law. I believe what I said, Your Honor, so they can all fuck off. Ma'am? In agreement with the plaintiff, this is case law that she is citing. In agreement with the plaintiff, quote, summary judgment is appropriate when viewing the evidence in light most favorable to the non-moving party. There is no genuine dispute as to any material fact. This is a different circumstances because they are arguing that you have admitted all of this and you kind of have admitted all of this. So that's different. The court must deny the request for summary judgment. The court's order on this is going to be interesting. I hope they have oral argument. Conclusion. If TikToker's statements are read favorably to the defendant, to her, to TikToker, it would read that she is believed to be telling the truth about Professor's role in the murder of the 4 University of Idaho students and that the affair with one of the victims. Additionally, the plaintiff has not proved any evidence that TikToker is not telling the substantial truth. Professor and attorney have continuously abused the judicial system. This is not the right direction to go with this. They filed a frivolous complaint, disrespected spirituality and TikToker and her beliefs. They've lied in every docket they filed. In the complaint, they don't are you talking about exhibits? They've lied in every docket they filed in the complaint to manipulate the court to believe lies about the TikToker. Your Honor, they keep lying. It's all just lies. What I'm saying is the truth, but it's all just lies, Your Honor. They have blocked the attempts to obtain evidence. You've asked for that evidence improperly. To prove that she is telling the truth about the role in the murders and the relationship with the victims and conspirators. Now they have filed a frivolous request for summary judgment. Whether or not the court has jurisdiction and if the court impeded upon TikToker's right to judicial impartiality is pending. Discovery is still ongoing. For the aforementioned reasons, the summary request judgment is inappropriate and must be swiftly denied. The court must deny the request for summary judgment unless it is for a complete dismissal of the complaint. That's not how that works. And punish plaintiff and her attorneys with sanctions. Anything less than the best is a felony. Anything less is an impediment to judicial impartiality for TikToker. Your Honor, ruling against me proves your impartiality. And any ruling against me is an impediment to my case. Prayer for relief. This does not, okay. Award TikToker all court-related fees in the amount of $100,000. No, that's $1 million. Court-related fees and sanctions for the amount of $1 million. Footnote 3. Sanctions totaling nearly $1 million were upheld by the Supreme Court for petitioners' attempt to manipulate the court of jurisdiction by acts of fraud, filing false and frivolous pleadings, attempting by other tactics to delay, oppression, harassment, massive expense, and reduce the respondent to exhausted compliance. That's not how that works. Dismiss the action with prejudice. You're not in the right pleading for any of this. You're not in the right pleading for any of this. This is not a complaint. The conclusion is you're asking the court to deny the motion. Fucking hell. That was a adventure. Oh, there is an exhibit. I apologize. Here's the exhibit. Exhibit A, tarot reading with the link to the tarot reading and links to Facebook. We're not granting that any respect. The professor responded. The professor responded. So we're going to get to that reply right now. And I don't know if we're going to have time for questions because I am going to run out of time. Because I did not think I'd be streaming for 3 hours today about this fuckery. I didn't think we would be here this long. So I'm going to zoom the best I can. The professor responded. Oh, you can't read that. Hold on. Let me fix my zoom. I zoom too much. That'll work. In her opening brief, Professor established the facts necessary to prove that the TikToker defamed the professor when the TikToker stated the professor had an affair with a student and then orchestrated 4 horrific murders. In her opposition, TikToker did not submit a single fact to support the validity of her false statements or to dispute the facts presented by the professor. She instead seeks to excuse her failure to respond to discovery and asserts her false statements fall under judicial privilege. Both arguments fail. Gouliard consented to electronic service, which is how Professor served her discovery, and the judicial privilege does not apply to statements made on TikTok. This case has been pending for nearly a year. It is time to end TikToker's baseless assertions and to begin to repair the professor's reputation. Professor requests the court enter judgment in favor of in her favor as to Gouliard's liability and set the matter for trial to determine damages. I don't disagree. Professor served requests for admissions on Gouliard. Gouliard does not dispute the fact that she responded to the request for admissions. She did. Where did she respond? Tell me more. And she excuses her failure by saying she was not served. Like her statements about the professor, the excuse is false. On June 20th, Professor served her first set of interrogatories, requests for productions, documents, requests for admissions to defendant using the email address. It's hyperlinked. Using the email address, the address on the filings, and listed in the system. They were properly served via email. Gouliard asked the court to let her use the CM-ECF system, and the court granted her request on the condition that she must follow all applicable procedures for electronic case filing, including but not limited to the local rules and electronic case filing procedures. The latter states that registration to use the e-filing system constitutes consent to electronic service. As a result, the professor properly served her discovery request on the TikToker when she sent them to the email address and provided them. Gouliard TikToker's failure to respond to the professor's request for admissions establishes the facts needed to grant a motion for summary judgment. This reiterates what was in the previous motion that I have covered. I am not going to reiterate it because we have got to zoom. TikToker has offered no admissible evidence to raise any dispute, let alone a genuine dispute about the facts. Even if TikToker could produce any evidence to the contrary, she cannot. Such evidence is inadmissible to contradict her admissions. This is all in the original motion. Judicial privilege does not apply. The court's already ruled on that. We know. Professor requests that the court grant her motion for summary judgment. She should also be granting sanctions. This is the second declaration in support. True and correct copy of the email. That's what I want to see regarding the first set of interrogatories. Email to the email address. And this is the email address that is on all of the pleadings. She puts it on every single pleading. Also, internet, not law nerds. Law nerds know this. Do not email this TikToker with the information she has provided to the court. Don't do that. We are observers. We're like a documentary film crew. We're just here to observe. We're not here to get involved. Do not email this woman. Just as a general best practices. Ms. Gouliard attached her plaintiff's first set of interrogatories, requests for production of documents, and requests for admissions. Thank you. Exhibit B. On July 13th, notice of intent to serve subpoena on Facebook. Greetings, attaches the notice of intent to serve subpoena. Oh, this was her using her email address, Ash is God, to correspond. So they are just showing that email address is the email address she's also using to correspond back with them. Exhibit C from Ash is God. Defendant's initial disclosures. Greetings, attaches defendant's initial disclosures. That's from June 30th. So she's emailing with them. From Ash is God, June 7th. This is her engaging with them. In the answer to counterclaim for the case, counterclaimant Gouliard attached countercomplaint as a new party. On June 2nd, she mailed a copy of the complaint, the accompanying waivers to request service. I have requested to have the waiver returned by email, same email address. over and over and over again, this TikToker was consenting to email. For those of you in the chat saying the email address explains a lot. Yeah. So that was a journey. What we have seen is that the TikToker has called the court ignorant, biased, has stated that she believes what she is saying. Her email address is referring to herself as God. And she blasted a family that suffered a horrible tragedy for her own ends. I was not expecting all of this today. It's been quite a lot. The patience of the judge is wild. There is a hearing coming up in this case, a status conference. It will be interesting to see what happens there. This court has to just be spinning reading each of these filings and is probably just taking them with a deep breath. Just so I'm real interested to see what happens with this motion for summary judgment. Real interested. I think there is room for the judge to grant the motion for summary judgment. I don't know if the judge will do that, but I don't know how you get around the rules of, I don't know what exception the judge would find to the rules. We will see. For those, we're going to get to Q&A. So let's do that quickly because I don't have a ton of time to do Q&A. So let's get to Q&A real fast. Original E asked, how has the court not lost its shit yet? This is just another day at work. And they have an incredible amount of judicial temperament and patience. Zoe asked, isn't this the same judge as Koberger? No. Koberger's in state court. This is a federal judge. 2 different courthouses, 2 different courts. The attorney for the plaintiff, Wendy Olson, is the same attorney that has represented the media coalition in both the Koberger case and represented the media in the Chad Daybell case. So it is the same attorney representing the media, but no, it is not the same judge. Motion to send the judge a bottle of the good stuff after this is resolved. Judges generally can't accept gifts from the public, but we can send the judge spiritual good wishes. So, and continue to look at the judge going, oh my. Judy said, I just want the trial televised. Federal court does not televise. Federal court does not audio record. Federal court does not do the things. For all of you that gifted memberships today, thank you so much. I'm going to get to some Q&As, not just in the super chats, but elsewhere. But I also want to say to all of you that are on the YouTubes and all of you not just on the YouTubes, so many of you have tagged me in your Spotify Wrapped for the Emily Show podcast. Thank you so much for that. It always warms my heart to see what else you guys are listening to. A lot of you, mostly true crime. I could have guessed that. Not as many of you into pop culture as I would have thought. True crime. True crime is the overarching interest, it seems. But for those of you that listen on Apple, that listen on YouTube, a lot of you listen on YouTube, we need YouTube to do like a YouTube watched or a YouTube played or something. They call it a play button. Let's do a YouTube played, because a lot of you are like, well, we watch the podcast here on YouTube. We don't get it Wrapped. I know you're here. I see you. I appreciate you. Thank you. I see you. I know you're here. Smurf Anna messaged you about Courthouse Becky. Thank you. I will take a look later on. For those of you that use Google Podcasts, I think that's been wrapped into YouTube. So YouTube needs a YouTube played. Maybe that's a better name than YouTube watched. YouTube played instead of wrapped, but I appreciate it. So I know you do. I know a lot of you don't use Spotify. I appreciate you. Nefertiti, good to see you in the chat. Emily, at what point does the judge say enough and award a judgment? There has to be legal grounds to do so. Summary judgment is the first opportunity the court really has to do that. So we will see. But the court can find liability on the motion for summary judgment. There's law to do it. But they can't award damages. So then it would just go to trial on damages, which is similar to what happened. Which defamation case? What's his name? But that was a discovery sanction. But the court determined liability, and then it went to trial just on the damages. Thank you, chat. Alex Jones. I was like, name. That one in the Alex Jones case. That can happen here. Wait, if you're using TikTok for marketing, then you are in fact trying to make money from TikTok, even if it's not directly from the platform. And exactly and completely agree. I don't think them accusing her of making money is defamatory. Sierra, mistress, I have been bad. Yes, I should have the spanking. Me too. I should have a spanking. Spankings all the way around. I need to fix my camera because I can see the bottom of my monitor in the corner down here. I have not readjusted after Dr. B streamed with me. I'll fix it a bit. Wendy Trauma Warrior said it's been a glorious week. Tuesday, I became a grandma. Congratulations. Today, EDB is covering TikTok defamation case on my day off. You're welcome. We're here for the TikTok defamation case. This case, I'm never going to give you up. I'm never going to let you down. I'm never going to run around and desert you. This case, we are following this case till the end. We are on this train. Everyone else, well, no, Atuzzi and Marquis are covering it too, but everyone else has moved off and on to other things. We are staying here. We are covering this case until it resolves. It is, I can't let it go. I can't let it go. Goosebump said, arguendo, could it be argued that TikToker truly doesn't know the allegations were false? She's pretty tenacious in her delusions. Goosebump, to get to that argument, you would generally have to get to a jury saying, I believe the things I'm saying are true. But you would have to get to objective facts for a basis of that truth. I need to do some case law research on whether or not that's a reasonable belief. I don't think a jury would find necessarily that to be a legally sufficient, reasonably belief. Yes, chat. The bingo card has blown up today. So Rick rolling is the only thing that's appropriate. Never gonna give you up. Never gonna let you down. Never gonna run around and desert you. All right. Steven said, as a neurodivergent, I wish my parents were as patient with me during math homework as this judge is with the TikToker. You are not alone, Steven. My dad was an educator and was like, I don't understand how you don't understand. I'm like, I don't understand how I don't understand either. Great. My little one does math backwards. I don't understand how it works. I'm just like, whatever works for you, buddy. Good luck. But it's how his brain works. We're on that level of dyslexia where he does his math backwards and his school has been working with it. We just try. This is giving Minority Report vibes a little bit. She's like, I predicted it to happen. I'm new to Court Watch. What does the GOAT mean? I think they defined GOAT as to greatest of all times, but Vincent Van Gogh is just our emotional support goat when sometimes we can't scream enough at our frustration. Who is helping TikToker write these motions? GPT? I don't know. TikToker, I think, is putting these things together. TikToker has made some misapplications of the law, but like logical arguments toward that misapplication. Legalese is hard, bro, but they have made linear logical arguments. So I don't know if a jury would find this to be a reasonable belief or a calculated, like, get out of jail free card. You know what I mean? Because this does not read as completely out of touch with reality rantings. I have seen those cases in criminal court. This has logical grounding in arguments. And then also the like, Jessica said, I could pull a few cards and do a reading for her. I mean, pull the fuck around and find out card. That's where we're at. Which card would that be? Justice? The Tower? Which card's the fuck around and find out card, chat? Bella Brat for you said, why do you think the judge has not shut her down yet? The judge has taken this case legally and methodically, and the court can't just say, shut the fuck up, get out. The court has to follow legal procedure and has followed legal procedure and legal argument. Enchanted Wing says, thank you for making my night. I'm dying from laughter. Please don't die. Oh my God, all this fuckery is keeping me from losing my mind today. Good. This is why I like covering this case. Breaking, did you see that Jamie Spears admitted in a depo to bugging Britney's bedroom? No, I didn't. I've been streaming. Did that happen today? Of course it did. I've been streaming. The chat is like, the fool, the tower with the fool. Is there a cup of justice card? There's a justice card. I will have to look. We've been needing to check back in on the Britney stuff that's going on. Yeah. Is she immune from sanctions as a pro se litigant? No, she is not. The court's going to be very cautious on that. And I don't know that there's much blood to squeeze from a stone with this one. Nisha, you good? This mess broke you a little. My brain buffered for a minute. Yeah, this one made me buffer. The TikTok lady did a trick to the paperwork she received and said she was going to use it as toilet paper. That was the, I saw some of those TikToks. Those were with the cease and desists. I have not seen them since. But the fact that she was communicating with the same email address, it's just done. Super excited to be here for the live normally in the replay crew. Lots of love. Thank you. I forgot to tell the replay crew that I love them at the beginning. We'll tell them now. Tower card and 10 of swords. I love that you guys are giving me the cards that works. The Empress says, I do math backwards and it works fine. Just see it differently. G explains it to me and he's like, this is how I do it. It comes to the right conclusion. It's just a very different way of doing it. While in Brittany, her sister has quit the jungle. I saw that her sister was on I'm a Celebrity, Get Me Out of Here, and apparently said, get me out of here. When is our next live trial coverage? I miss it too. I'm not sure. I'm going to be doing some sections of stuff. Brit's sister is in an I'm a Celebrity here in the UK. She bailed. I saw that. Let's see. Thank you, Miguelina. I actually have to hard stop just about now because I've got to drive. So chat, I do have an appointment. I have to zoom. I appreciate you. YouTube, not YouTube. You need to be on the app, the Lawnerd app. This case broke my brain today. LawnerdApp.com, because next week I'm going to be out of town briefly. I'm going to be updating you in the member spaces and a little on Instagram about what I am doing with YouTube. I'm really excited to go out to LA to do some stuff with them and see friends and family and all the things. But Tuesday, I will not have a stream. When I will do a makeup stream, I'm going to try to do a makeup stream next week. So we have 2. Wednesday, there will be a new podcast for sure. I may be in the chat depending on the Wi-Fi on the plane. So fingers crossed for that. I will keep you updated on the travels and the adventures and all the things. What else? With all of that, I will try to do 2 streams next week. We're just going to have to see when. So stay tuned to the app because we will have some schedule shifts next week. I will have to keep the mods in the loop. Do we have a food court Friday coming soon? We have some really good stuff I've been saving for food court. So we are in need of Brittany updates, food court updates, Young Thug Rico case. We haven't even talked about that case ever. We need to talk about those opening statements and using lyrics and Rico cases and the rest of it. We have so many things on the agenda. I'm trying to kind of update the cases we've been covering and then weave some new ones in. But yes, we are definitely due for food court soon. Lawnerds, I love you. I appreciate you. I will be doing polls in the member spaces about what cases you have been missing next week. So keep an eye for that and I'll let you know when those are up. And then we're going to have new members only streams at the beginning of the month because we are getting into December. Oh my God. And remember, to our top tier members, we are adding a bonus Zoom call into December. And I will be giving details on that in your member spaces as well. And with that, Lawnerds, cheers. I will see you soon. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.